After only Thursday, Thursday. Ah. Yes. Fresh. APMC Wednesday. What is that? Tour.
Number 41 to 47. Number 9, 48 to 54. Number 10, 55 to 59.
Similar matter. In this also delay. There's a delay.
Yes.
Same delay. The delay is same.
The delay is
7 years.
zero.
Same one. Subject to entire deposit within a period of 4 weeks from today. Before the trial court. You're depositing before the trial court, right?
Yes.
Notice. It's in motion. Second, same. Yes, Mr. Narayan. Are you still residing in the said premises? Indicate that you are running the shop. What is the material produced by? Correct. What is the material produced by you to show that you are residing in the said premises? Till
Temporary electricity connection is kept on living.
till what time you had this temporary connection? Is there any eviction proceedings against you? No proceedings. You are not been evicted.
Is that the part number 2 I will complete the part. Is that the property itself is another temporary connection.
Now, temporary connection was given to you from when?
2005.
2005.
2006. 2006.
Up to?
Up to 2021. Completely disconnection.
So from 2021 to 2024, there is no electricity supply to your premises.
There was an electricity connection. The other number is continuing the same. Review of the complaint submitted by the restaurant number 3.
Correct. Now, the court wants to know as to from when there is a disconnection. When was the disconnection? When was the notice?
The connection issued on 1st July 2020.
No, you said the temporary connection was given up to 2021. You take notice. H.V. Devraju, learned counsel to accept notice for respondent number 1. So petitioner counsel to serve the petition papers on the learned counsel. Issue emergent notice to respondent number 2 and 3. Learned counsel for the petitioner submits that the petitioner is residing in the said premises under leave and license executed by one MC Jayalakshmamma, the predecessor of respondents 2 and 3, no? 2 and 3. Mother of respondent number 2 and 3, no? mother of respondent number 2 and mother-in-law of respondent number 3. And the petitioner had obtained electricity connection from the had obtained temporary electricity connection from the year 2006, comma. Now, at the behest of respondents number 2 and 3, the
Respond number two.
only respond. At the behest of respondent number 2, respondent number 1 authority has issued the impugned notice of disconnection. Since the providing of electricity is the basic amenity of the citizen, among the respondents herein, respondent number 1 is directed to restore the disconnect ಮಾಡಿದ್ದೀರಾ ಈಗ? Directed to restore the electricity connection supply to the petition premises on temporary basis, which was existing from as to the existing RR number or the new RR. Yes, Mr. Chair. How much years delay? From when? You have been paying for all the years from. You just verify what has happened. What? You just correct it. Where have you to correct? What is that? That is the difference. You have to rectify that certificate. So now, yeah, or get a legal head certificate saying that these are the LRs of so and so. You may have to do this. You get instructions. All the respondents, SCGP to accept notice for the respondents. Copy, sir. Petition respondent to get necessary instructions by the next date of hearing. Please this matter on. Yes. 11th. 11th. Day after tomorrow, right? You will. Is it possible? Is it possible for you to get it? Monday. In preliminary hearing. Tuesday, Rajana. Tuesday. Tuesday in preliminary hearing. Yes, Mr. Yes, Mr. Gangadharaya. For the defendant. This is a dispute is regarding the 8 guntas of land. There is a bund between the property. There is a bund. Canal.
After my case is that I purchased the property in 1958 from my tax. We registered saying who was granted from the law in the year 1940. Their case is that in the case of the client is that the property in the year 1980. Went down for 85 meter, not from the there 19.
Did he file a suit for declaration?
But declaration is filed with respect to the survey number 161. If you have a possession in that property, there, both side of the canal, there is property belongs to the defendant. Eastern side of the canal, it measures 1 acre 5 star or western 1 acre 25. Eastern property, eastern side of the property is like that it is the canal side.
The dispute is regarding the 10 guntas of land.
Yes.
10 guntas of land.
Guntas of land. Even 90 and his father sold the property in favor of one Sanjay Gowda. We registered sale that is exhibit D3. D1. Issue. In which the extent of 1 acre 36 to 34 gunta was only mentioned. That property was purchased by the plaintiff, repurchased by the plaintiff from his children of very same purchaser. At that time, when he repurchased the property in the 1984, 1984, exhibit B1, they mentioned it as Calcutta Karab. There is no explanation with regard to the instruction of the Karab.
But this is in the year 1934, before your sale deed. Before your sale deed is in the year 1958. Your sale deed is in the year 1934.
84, 84. In the 84 sale deed, his vendor earlier sold it to the plaintiff and his father sold the property to the vendors of his father. So that sale deed was.
When was it sold? When did the plaintiff's father sold this property?
Plaintiff they sold the property in the year 1965. An extent of 1 acre 34 guntas. There was no Karab mentioned. And when they repurchased in the year 84, his vendor mentioned that along with 34 10 guntas of Karab. And with regard to that, there was no explanation either given by the plaintiff or the witnesses, and there is no document forthcoming before the court below. Your Lordship is well aware that Karab will only be declared by either by the revenue department or by the survey department. There is no such evidence placed before appellants before the trial, defendants plaintiff before the trial court. And moreover, on the instance of the plaintiff only, a commissioner was appointed, commission report was filed. The trial court has failed to appreciate not even looking to the commission report. There was no mentioning about the series of the exhibits also.
What did the commissioner opine? What was his report?
Commissioner basically said there was an encroachment of 10 guntas of land by plaintiff belongs to the defendant. And that report is exhibit C told me.
Is the records come? TCR to be secured for court. TCR, let the TCR come. 2017 till 2024. There was now the injunction has been granted from the year for so many years. Now it has been continued. Yes, Christian Nagesh. Who has moved this appeal? What is the suit for? Artisan. And who is the Lakshmama? Who is the plaintiff? She's the mother. And mother against the daughter-in-law. And now what did the trial court do? 1/3 share. Why 1/3 share? Alla grandson idrano. Now who is in daughter-in-law is in appeal. When did her son die? Two 2012 he died. Sridhar Murthy. Dispute between mother-in-law and daughter-in-law now. Why don't you settle it? Govindaya, when did Govindaya die? Oh. So this was his, when, this is 2012. He died. How many properties? Only one. House property? She is, what is her age? 80 years. Then why don't you settle it? So there are other daughters. Why were the daughters not made a party? Then now this suit was, and how was the suit maintainable then? Sunshade is asking. Why don't you settle?
ಅವ್ರಿಗೆ ಕಂಪಲ್ಸರಿ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ವರ್ಕ್ ಸಿಕ್ಕಿದೆ, ಕೆಲಸ ಸಿಕ್ಕಿದೆ. ಓಕೆ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬರ್ತಾ ಇದೆ.
Yes. When do you want? No, not next week. This week only. Any date under you are asking for time. This court is not asking the time. Any date. If the court is asking time, you should say any date. Huh? Not 13th. Before that. 12th. 12th. At request of the appellant court. Calling. 455 days in recalling the order. Huh. Right, Narayan Swami. No. PB Raju. You appear for United India Insurance Company. The whoever name appears in the cost list, they have to appear. Now PB Raju was there, Janardhan Reddy was there. Any of the councils would have appeared before the court. This is a company. See, you can understand a private an individual. They would have many reasons, but not an authority or an institution. You see, there are so many standing councils for this United India Insurance Company. PB Raju was there, so Janardhan, they should have come and made a submission. They should come to the court and say something. How is the court supposed to know anything? 455 days, not 1 day or 2 days, and then you were not. I think the institution did not even bother to say as to what happened to the petition. Now, what is the petition about?
Participated entire trial stage services were terminated. They went on appellate tribunal to discuss the they gave a petition spoke about giving them liberty to go to legal court. Legal court, the again I found wrong. So actually saying that one of actions on which we relied upon during the proceedings that was not marked. So this was a matter which is not followed up the day. After an inquiry was held, and that was by order of the certain side and an order to reinstate them back on the session possible. Challenges that got have come to the this is why I'm these records of what happened on the basis of which the order was passed. One is question of whether it was violated or not to be set aside order. Second is the are just not the community. Appointment. However,
Caste certificate was not produced subsequently.
no, they are not even subsequently. Council gets a record of so. They are also not examined. He said that he must diploma matter is the result of this. By the order of those people, that is the employment is other. That will be based on the main Puna.
Yes, Mr. This mic is here. Even recalling password. Let him know.
My Lord, serial number 8, I appear for the petitioner.
Yes.
My Lord, last time I had made a submission, my Lord, about the application. My Lord, due to inadvertence, my Lord, this has been stopped. My Lords could record my submission that we will restore.
To be continuing to pay the amount.
Yes, my Lord. Yes, my Lord. Due to inadvertence, it was stopped. It was in fact by an order dated 8/2/2019, we were directed to pay. And we were paying only from the month of February 2024, my Lord, due to some inadvertence and administrative lapses, it has been stopped. My Lords could record my submission, my Lord. We will continue to pay and pay the balance also.
It was put on 8/2/2019. State the
No, my Lord, directed to pay 17 BUH.
state the order passed by the tribunals, Labor Court, and directed the petitioner to pay the respondent last drawn wages. The order was stayed, right? No?
My Lord, the order was stayed much earlier, my Lord, in 2018 only.
This court on 8/2/2019 directed the petitioner to pay the respondent the last drawn wages from the date of the order passed by the Tribunal of Labor Court. The respondent workman filed an application seeking for restoration by continuance of the interim relief paid to the respondent since past several years at the rate of rupees 4,600 per month. It is the contention of the respondent workman that from the month of February 2024, 17B wages have been discontinued. Petitioner counsel, what is your name?
My Lord, Kashif.
Submits that due to inadvertence, the establishment has not paid the 17B wages as ordered by the court on 8/2/2019 from February 2020. Then council submits that the establishment would continue to pay the 17B wages as ordered by the court on 8/2/2000.
Please.
The submission is recorded. In light of the submission made, I1 of
24.
24 is allowed. Petitioner establishment to pay the 17B wages as ordered by this court on 8/2/2019 till disposal of this record.
In all the three matters.
All one connected, all matters covered.
Grateful.
Please. Have you filed your objections? Any objections to the amendment application? Have you filed objections? Madam, have you filed objections to I1 of 2023 for amendment? To the amendment application? When did you file it? November. Sorry. What is this amendment? Mr.
Petitioner management seeking to challenge the domestic where they involve not balance proper. This what was also asked and the challenge is about standing liberty to release their I think the validity of that case that was the
So that can be allowed. That application has to be allowed. We'll say from the date of filing of the application. It will be only from the date of filing of application. Yes, Mr. Consul. Yes, Mr. Muralidhar. After 19 months. 19 months.
I have challenged the
When did you challenge the order of domestic? When was the order of domestic inquiry passed? So the law is interim orders has to be on the just a minute. Annexure? When is the date? Domestic.
And during the pregnancy of the liquidation, the tribunal disposed of the main matter itself. And that order is under challenge.
To challenge that is on the year 2017. When was the when was the order of the tribunal?
All of the main order of the tribunal is 15 September 2017.
In September.
So, the order first on domestic inquiry merges with the final award. So, since the tribunal has set aside the domestic inquiry, I am saying before this order to amend the liquidation, that order also.
What's that order?
That is order on domestic inquiry.
No, when the order in this court, by this court, where is that order? Order of this court in domestic inquiry.
Because the main order was passed. No prejudice will be caused.
When was the 17th wages order? When was it ordered? First?
Maintenance in the upper section that was not added. Isn't it? Date of superannuation. Thereafter it was not added. This is super, date of superannuation is not.
When was the order passed? What was the interim relief granted by this? From 2018, what is the amount? Have you paid the 17B wages? When did he attend superannuation? When did he attend superannuation? When did he attend superannuation? 14/8/2023. So he is entitled from 2018. When was the order passed by this court? Adam, interim relief as 17B wages was granted when?
It was not granted.
It was it was granted on 35/2018. There's an order by this court directing you to pay 17B wages. There's an order. Then, so that is why it has been granted here. Yeah, what happened?
During the winter safety.
So, after that, only that the court is asking you, 17B was ordered by this court. They say that you have not paid 17B wages. From 2018 till 2023, he is entitled for 17B wages.
No, attaining the wages entitlement is still the employee attends superannuation.
That is what I said. 14/8/2023, he attains superannuation. That is the submission of the respondent. When did he attain superannuation? When you read and from Passover. Passover. Yes. Mr. Bandari, what is this application? Seventeen B. ಕೊಡ್ಬೇಕಲ್ವಾ? You have to pay 17B wages. Reinstatement ಆಗಿದ್ಯಾ? Have you reinstated him? ಎರಡು ಮಾಡಿದ್ದಾರೆ. He has filed an application. Password ಬರ್ಲಿ ಅವ್ರು. Password. Now. Yes, when do you want? Tomorrow. They have filed some status. They have filed a memo now. Yes. What is happening? You appear for whom? 14. So how many years? Only one. Have you served the memo upon the other side? Serve the copy. Petitioner has filed a memo indicating the present status of the employees who are absorbed by the respective respondent. Petitioner to serve the memo on the learned counsels. This matter next week. You file your affidavit. That is it. So all of who all filed this affidavit? Who all affidavit filed? Affidavit filed by respondent number 9. 9 has filed. You have filed. 15. Have you filed affidavit? Have you filed affidavit? And 16, respondent number 16, have you filed your affidavit? No, affidavit you have to file immediately. That was the order of this court. But affidavit, we want an affidavit, not a memo. Affidavit is to see that you adhere to that affidavit. Memo doesn't make any sense. So you file an affidavit. That is the order of. Madam, just a moment. Let us tell the respondent what they have to do. They are not even complying that order. You have to file an affidavit to that effect. Why are you filing a memo? No, memo you can't file. You have to file an. No, you file affidavit. Memo we will not take memo. Yes. You should tell who are the respondents who have taken them into employment, Ms. Madam. Who are the respondents who have taken into employment?
We are 9 my lords was completed the process of.
So 12, 15, 17, 19, and 24.
R24 has recruited 5 persons, my lords. R24 has recruited 5 persons, my lords. For the other 3 persons that we have interviewed, there is no further communication.
The respondent number 12, who is appearing for this? They say that no further communications regarding the 4 employees. But then you have to state within what period you will be taking them into. You look into this affidavit now. They have filed a memo stating that only respondent number 9, who is respondent number 9 here? Sorry, KIDB has only taken all the 6 employees and they have also reported to duty. About others, that is respondent number 12, 15, 17, 19, and 20. Though you have absorbed them, you have not given further communications to them. Correct. Now you have stated so, right? So respondent number 12 has filed. 9 is okay. 15? Fine. So you'll be taking them. How can we say that should be a point? You should do the process. You should do the process and then submit to the court that you have done it. What is the affidavit you have filed? 11 employees. Have you issued communications to them? Appointment orders have been issued. Where is your affidavit? 8/8/2024.
Flip.
The respondent number 15 also filed.
And ಎಲ್ಲ collect. Okay.
Why did you file another affidavit which was taking away the earlier affidavit? What is that? Ah, ah. So now you're willing to take how many employees? 3. 11. How many affidavits did you file? What is that memo? You have filed an affidavit saying that you had agreed to take 11 employees. Then what happened? It is submitted that the government has convened a meeting on 7/7/2024 wherein agreed to take 11 employees to Lidcut. Out of 11 employees, huh? So 15. Then next is who? R17. R affidavit. So you have filed an affidavit. R19. R19. Mysore Sales International Limited. They have filed affidavit. Yes, they have filed. What about 24? Karnataka soaps and detergents. You appear, government. You appear for this. Correct. They had to serve the copy on them. So respondent number 18. 28. You file an affidavit to them. Then if counsel appearing for respondent number 18 subjects that one employee, namely, what is his name? KC Lingaraju. C. Lingaraju has been absorbed in the respondent number 18 establishment on 28/8/2024. And the council submits that an affidavit to that effect would be filed within a week. Respondents number 9, 15, 16 and 9, 12, 15, 16 and 19 have filed their respective affidavits indicating the employees observed and the process in progress. 16? So no, has filed their respective affidavits. 15, 16 and 19 have filed their respective affidavit. Yes. Now next one. In light of that affidavit, we have to dispose of this liability.
Please, my lord, the government will serve copies of the affidavit, my lord. Petition the next week.
You serve all the affidavits on the petitioner counsel.
So the R24 and R.
Responding consuls appearing for respondent number 9, 12, 15, 16 and 19. And also 18 to file to serve the copy of the affidavit on the petitioner counsel. Now what?
R24 also will be available.
No, 24, where is he? Have you served?
File the,
Let him come. 24 is Lidker, somebody has to appear for them. Karnataka soaps and detergents. Nobody, no counsel appearing for this respondent number 20. Based on Monday, Tuesday. Annexure N.
Now, my lord, what happened, actually, in March 2019. Immediately after that, within 2 months, Pavitra to applied for those payments the state government, but the direction to this corporation is not to work out. The roster point from 27,470 till 15,500. But within 2 months after election, young my lord, if your lordship could see the first document, seniority is 28,600. This is the final seniority.
Annexure N.
But annexure is no more there. What I am finding is not now. Section young my lord, it's not no more there because of the final seniority. The annexure young is a provisional list. He is provisional list. A submission of that list. That not a proper provisional list. The first page itself will not say have any objections by the. But I want to forget what was happening in corporations. Provisional list itself they. That's the reason we are adding more submission without taking. But now my lord, the provisional list has become final list. Now my lord, that prayer is your worship, the provisional list is. What is what?
Yes,
What is what? 28,000. Because they are collection, the unreservation. Your lordship could come to the first prayer, the first time. Speak with the Adesha. But you know, now, paper they tell. Again, get October they want to change. They are in a published money. They are 7 days time put. 7 days is Indian council objection. So the council issue. Now they names now found that the page number is provided to the government.
yes.
And it comes to page 65.
Yes.
ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ನೇಮಕಾತಿ ಪಡೆದ 1849 that column may not provision with time because ambiguity may not date of entry.
Yes.
And then because for all purposes the service is recognized in the corporation the day on which because the government order may not the board resolution is dictated. appointment consequent on availability of vacancy. And they will start the that's the reason, you know, they found that applicability, that column itself is their date of birth, date of entry is date by law at page number 70. That is a serial number
Yes.
202.
हाँ.
Alligator. सरकारी आदेश का कोई आते हैं. Page 65.
No, page number 70, page number 70.
Page number 70.
70.
Serial number 206.
Yeah. Yeah.
सरकारी आदेश का कोई आते हैं.
Yes.
Not only these petitions for remote. Page 65. This date of probation is shown as 54.
Yes.
That's the reason I asked them why only this person is happy. That's a mistake. There was a lot of probation, service resistance not have because we have after the horizontal, after the horizontal,
Page number 280.
Immediately after the selected, horizontal data, after horizontal is selected, seniority.
Yes.
228. The continuation. Enter the software. First 20, how we got. They are totally better. Often find it that people about pass on one day. The number of posts that was notified was 1499. Regular advertisement.
Yes.
They can take up the place better than what average of the vacancy grows better. They were patient on it. Therefore, most of them got in 95, 96. The last document, last page, is not I was a bit philosophy like the mistake of my shaman. I have produced this order of probation. Because the date on which the order of probation. These are
Serial number? Lakshman.
So it is big.
V. Lakshman.
Shaman. More. Shaman. The last page.
Last page is V. Lakshman. Yes, yes. Yes.
That should not be
Yes.
His date of probation is 27,990.
Where do you get that?
ಆದೇಶ ಹೊರಡಿಸಿಕೊಳ್ಳುವುದರಿಂದ ಅವರ ಮುಂದಿನ ಹಾಜರಾತಿ ಪರೀಕ್ಷೆ ಮಾಡುತ್ತೇವೆ ಮುಂದೆ activity the entire seniority runs into 7 pages. That's the only activity. Activity is not given to connection. That's the mistake. Now we know if you're rushing. That's the prayer. The prayer is not just action. Action, when we're not put on the name.
It's in light of the final name.
Because action, we have to put rushing to the first page. Action, we have what we say. Any of the three candidates.
They don't dispute it as provisional seniority.
they were called upon to pay.
Yes.
In the objection 6 30 days, 500. Definitely they are not filing. Because their representation action here is in August. Much of this seniority, final seniority has been done. And I am also informed that cannot because what we clarified the final seniority. So this is the time of order because they like active implement in the time of therefore 7 days time was granted. These parties submit their objections by publishing the same in the website. So no objections were received by the
Yes, Mr. Thompson. Yes, Mr. Muknappa, how does this writ petition survive now? You have challenged the provisional seniority list. The final list is already prepared long back. You have not filed objections to the provisional seniority list as well. One ambiguity that can be corrected insofar as the one who is at serial number 4.
It's also petition.
But there exists the
Petition number 26
Yes, 20 serial.
26. But if he was not engaged, he would not have come. That means he not remained out of it.
Shama 9.
What he wanted was 93. Really 93 was given to him, not have come to. Because he was given 93 for lots of the.
Yes.
and not for that is still my representation. I think here paragraph 5, page 160.
Yes. When was the final list prepared? After the preparing of the final list, you have given this representation.
And every two, the one who is not in it.
Yes, Mr.
So kind of page 162 paragraph.
Okay. 162.
In page 162 paragraph 5.
Yes.
The further submitted in our data pension appointment has not been correctly shown in the senior months. But in some cases, date of appointment and as well as the date of probation are one and the same. We submit that there was a delay of 3 to 5 years in placing us on probation. We submit that in the corporation, the seniority of an employee of all purposes is considered the date on which the employee is placed. The seniority counted from the date on which an employee is placed on. There are two things I want. One is the date of initial appointment, the date of probation. Now, in my case, there was a delay of 3 to 5 years in placing us on. Now,
Did you challenge the final list here?
the question is this.
Anna, is the final list challenged?
I'm not challenging the final senior interest yet. Question of challenging the seniority which arises. If I am challenging the ranking assigned to any of my juniors or otherwise also. I am not challenging the ranking assigned by the corporation. Which will also kindly appreciate. I can understand if any affected parties are there. Then I have to challenge the
In the
seniority.
final list, there is the date of probation mentioned. Is it not?
Now I will tell you what had happened was.
Is it not mentioned?
Now they have deleted because up to 2019, the date of appointment, date of probation, everything was there, but now, 2019, Lordship kindly see the development has produced the senior list in 2019. From 2019 and onwards, during the pendency of the petition, the initial appointment they have not shown in the senior list. What was shown is the date on which an employee was brought on probation.
Come to the final list, page number 65. Your date of appointment, is it not correct? 4/6/1969, 10/6/1974.
We get up our first petition, 1850.
Yes.
Now, what they have shown is, they have not shown the date of entry into service. Then what was shown is the date of probation. Pariksharnarthyayi Dinanka. This date is 29/9/1980.
Yes.
Every employees, they have opened the services, SR is open. In respect of this petitioner is concerned about the services. They have shown the date of entry into service as 1992. Why it can't be in respect of other employees? No, you want to kind decision.
Which petitioner you are talking about? What about the other petitioner?
That is my grievance is without saying that has not been entered in the petition, there's a first petition. What's the time is date of the probation as the date of case.
Yes.
Seniority list, the provisional seniority list was published on 1/1/2019. 1/1/2019. One second.
18/3/2019, annexure M.
Now, date of entry into service, date of provision,
In which annexure,
this was in 2019.
which is that?
The senior list. Senior list is dated 1/1/2019. This was published by notification dated 18/3/2019. Annexure M.
Annexure M itself you are placing reliance, that is all provisional list. Annexure M is the provisional list which you are challenging before this.
1/1/2019. 1/1/19, page 1/1/99.
Page number 147, annexure M.
1/1/2009. Annexure M.
Hey, what is your grievance now, Mr. Mukhnapa? What is your grievance? Is it the 1992 is it your grievance that 1992 persons who were placed on seniority, you have to be placed in par with this 1992? That is your writ petition papers.
Writ petition, I made a submission, one is that. Under the 1992, there are regularly selected candidates out there. They are placed above us. I am not claiming any seniority.
But that is your,
regularly selected
The
candidate.
entire petition amendment is to the effect of 1990.
745 and that one. All of them were appointed by virtue of the government order.
Mr. You said in your entire petition papers, it mentions about the notification of the year 1992 and about the placing of those persons who were recruited in the year 1992 above you. That is your grievance in your petition, if you look at your grounds. But in your paper, that is a prayer, you say that the provisional seniority list dated 18/3/2019 by effecting the proper necessary corrections in the probationary. What is that correction you
The
want?
correction is that, that the one is the date of initial appointment. Initial appointment and as well as the date of probation, you have to vote on this some cases.
No. See, now they've given the final list and the provisional list also, which you have produced at Annexure M. There is no initial appointment itself there. It's only the probation which is there in that.
So your Lordship,
Is it not?
Now, page 147,000.
And then let us clarify. Annexure M only is your provisional list itself. In that, is there the date of appointment mentioned?
Yes,
Where
it's
is it?
147,000.
Please. Really there.
Devakarta Dinaka, first petition, 4/11/90. Our probationary date 4/11/90. Every one day is Saturday.
Please, fine.
Similarly, even younger able, see 760, 760, Narsimurti, date of appointment 5/10, probationary date 5/10/95. Again, in some cases, they have shown serial number, number C. Date of entry into service 5/3/1992, probation 7/9/1995.
No, what first grievance is not mentioning the date of appointment. Not mentioning the date of appointment.
Shamanai case 93 correct correction ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
Out of 27,995.
ಅದು serial number 749.
Yes.
So my only grievance is this one, that is one today. The first grievance is that it can't be date of appointment, date of probation can't be
Correct, fine.
one and the same.
Yeah.
Because it is my case, in some cases, they were placed me on probation after 1 year. Some cases they placed me on probation after 2 years, 3 years, 4 years.
Next, what is next?
Then another one is that in this scenario, what the thing was, one is suppose in case if the date of mention appointment is correctly shown, apart from whatever may be the date of probation, then that period, if I work, I am entitled, the employees will get, to gratuity other benefit, there is one way. Then they will take this all other benefit from 1995 and what all substitutes also. I think that's the reason why I have shown service register. Service register, they have said that in respect of this birthday is recognized as that. They have shown the date of entry into service 1980.
Yes.
Now, your Lordship, I kind of see what happened, government order, makes it very clear. That even though all these employees were appointed by virtue of the government order, they should be treated as a salary. Yes. They will be no doubt they will be placed below them, regularly selected candidate, keep them as a selected candidate. When it's a selected candidate, then the circular also makes it clear, even assuming if the vacancies are not available, continue to, even a supervised post also, they should continue to get. They should provide. When they have continued to work. That is the reason why I said that. Yeah.
Now, what is your specific prayer, Mr. Mukherjee? What is your specific? Two prayers you said. One prayer is that your date of appointment is not mentioned in the register. So one thing. Next is what?
The next prayer is the probationary date. That's why I said that. When you are placing me on probation, then how this has to be worked out, that is very much forthcoming in the government order. I mean, the circular issued by the court. That has not been strictly followed.
When did you challenge that? Have you challenged the final list now?
I need not challenge the final list. There is a mistake on their part.
You did not challenge the final. Conclusion
The
is?
seniority list, I am not challenging the seniority list. I am not challenging. I have no grievance against the ranking assigned to us because we are in a particular block.
So your contention
We are in a
is,
particular block.
understood. Your contention is you should not have been placed on probation at such a belated stage.
Rental is very much.
When were you placed on probation?
That depends upon.
When were you placed on probation?
Right, sufficient. I asked that we were placed on probation in 95, 96, 97. I would do a list.
And when did you
I can
challenge?
list also. Not for kindness in the list what I have given.
Yes.
The first petitioner was brought on probation in 95, 4/11/95. Second petitioner in 22/12/95. Third petitioner on 7/12/1996. Fourth petitioner on 1995. Then again, you know, that the eighth petitioner was on 31/1997. 96, 95, 90. I have one list. This is in accordance with the senior testimony I have given it. My only submission is there. From 92 and onwards, more recruitment was taken place. I can understand if the vacancy no, but vacancies are that's the reason why every month they should report to the head office. Number of vacancies are available and number of employees were placed on probation. All these things are not been done by some. Just you can't place me on probation as and when you wishes and all the depending upon. Now what will you do is delaying placing me on probation. My submission is saying that development has always said the limit of not involved in a default case. I agree with it. If they are involved in any default case, they are not in it. I agree with it. What is it? Absolutely nothing is placed on record of. Even the statement of objection is not put. Therefore, my respectful submission is by looking into the things not agreed on the board research, the circular. The board has given certain guidelines that has not been properly implemented.
What was that resolution? 1993.
Annexure H. Annexure is page 100. About ಹುದ್ದೆಗಳು ಲಭ್ಯವಾದಂತೆ ಪೇಜ್ 100. ಹುದ್ದೆಗಳು ಲಭ್ಯವಾದ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಎಲ್ಲಾ ಅಭ್ಯರ್ಥಿಗಳು ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಕ್ರಮಾಂಕಕ್ಕೆ ಅನುಸಾರವಾಗಿ ಪ್ರೊಬೇಷನರಿ ಆಗಿ ನೇಮಕ ಮಾಡಿಕೊಳ್ಳಬೇಕು. ಪ್ರತಿ ತಿಂಗಳು ಆಯಾ ವಿಭಾಗದಲ್ಲಿ ಈ ರೀತಿ ನೇಮಿಸಲಾದ ಅಭ್ಯರ್ಥಿಗಳು ಕ್ರಮಾಂಕ ಮತ್ತು ಹೆಸರು ಇತ್ಯಾದಿಗಳನ್ನು ಕೇಂದ್ರ ಕಚೇರಿಗೆ ತಿಳಿಸುತ್ತಿರಬೇಕು. ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಸಮೇತ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಎಲ್ಲಾ ಅಭ್ಯರ್ಥಿಗಳು ಒಂದೇ ತೆರನಾಗಿ ನೇರ ನೇಮಕಾತಿ ಎಲ್ಲಾ ಅನ್ವಯಿಸುವುದು ಗಮನಿಸಬೇಕು. ಹಾಗೂ ಈ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಎಲ್ಲಾ ಅಭ್ಯರ್ಥಿಗಳು ಕಾಯಂ ನೇಮಕಾತಿಯನ್ನು ಕೊಡಬೇಕಾಗಿದೆ ಎಂಬುದನ್ನು ಗಮನಿಸಿ. I only rely upon this. I already the entire the guidelines what the circular issued by the corporation. That has not been seen. The delay ಪ್ರಶ್ನೆ ಬಂದಾಗ ನಾನು ಹೇಳಿದೆ delay ಪ್ರಶ್ನೆ ಇಲ್ಲಿ ಯಾರಾದ್ರೂ affected party even in the earlier what it did was 1992 2011 administrative mistake and so much they did corrected it. They also produced this.
You give the date of their appointment against the probation date. No, why don't you give that? No, in the register of the petitioner number 1, it is mentioned the date of. Why don't you give the date of appointment?
The date of appointment for all workers. All the time.
Correct, fine. See, fine. You take the date from the date of probation also, for all purposes.
We should take into consideration for meeting them on probation. That they will not question. But 95 to 2000.
No, we can understand. Why don't you take the date of appointment in the service? You insert the date of appointment.
That date. Or we will not temporary. What is
No, you can say that it was for what reasons you were. Then you consider their representation.
their prayer? In the prayer. The TV of the TV of the these are the time respectively of the please to extend the benefit of our service, that is from the date of our admission appointment, by placing us on probation absorption and emotional pay fixation, together with all consequential benefits, by placing us in the appropriate place in the seniority character published by notification.
Then you pass, give an endorsement to the setter. No, you give an endorsement to the setter, right? To their representation, stating that for what reasons you are unable to put them into or show the date of appointment.
The entire case not to
Please.
up to those grade of it. They want their placement to be done in terms of financial year. Even this is also not there. Because this
Then why-
representation
Allah,
will
this-
not survive for consideration.
No,
You know,
no, they are asking for a simple thing. They are asking, please show the date of appointment.
they're not saying.
No, then you say, we will show the date of appointment, but rather you will be not entitled for what reasons? For what reasons that you can mention, Allah?
What we say. Originally, show the date of the day. I get the day. Not by exceptions. Then after the publication of this is for a work of public card. I cannot alter this at all.
Correct. Why don't you consider the representation and pass an orders on this? Now they have said that there is a representation given by them.
I have submitted the right of where that. They don't say we're not giving my initial date of appointment. They are aware of it. They gave me to service, but I've given the initial date of appointment. The Washington 16.1990.
Where is that in your objections?
Today I find this. Now, page number 228. That's the initial date for all of them, for all purposes. 16.93.
See?
193. I brought them for all these 286. This is the list issued pursuant to the resolution.
Pursuant to the government order.
Government order and the government only says
14/5/1993.
order.
Yes, yes.
David Kacheri actually okay.
Yeah.
And advance for into Sarkari Adesh. ಏನಿಲ್ಲ ಅವತ್ತು ನೇಮಕ ಮಾಡಿಬಿಡಬೇಕು ನಿರ್ವಾಹಕರು ಬೆಂಗಳೂರು ನಗರ ಸಾರಿಗೆ ವಿಭಾಗದ ಪ್ರಸ್ತುತ ಆಯ್ಕೆ ಪಟ್ಟಿಯಿಂದ ಕೊನೆಯ ಹೆಸರಿನ ಸಮಾಜದಲ್ಲಿ ನೇಮಕಗೊಳ್ಳಲಿರುವ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಹಾಗೂ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಪಟ್ಟಿ ಇದನ್ನು ತಗೊಂಡು ಮೆಲಾಟ್ ದೇವರ್ ಮೆಲಾಟ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟೆಡ್ ಮೆಲಾಟ್ ಟು ಡಿಫರೆಂಟ್ ಡಿವಿಷನ್ಸ್ ಮೆಲಾಟ್ ವಾಟ್ ಇಸ್ ದೇರ್ that big ಮೆಲಾಟ್ up to ಮೆಲಾಟ್ 1000 ಮೆಲಾಟ್.
According to you, the date of appointment as per the government order and as per the resolution passed by the corporation was on 7/12/1993.
All purposes not they start at 16/93. Why it is not recognized melody? It is a Kudovu, a permanent Kudovu, Atari Kumastovi.
Yes. Yes.
Study name of that Yabo, page 100. Probationary name of that Yabo.
Yes.
ಪಟ್ಟಿಯಲ್ಲಿ ಎಲ್ಲಾ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ತಾತ್ಕಾಲಿಕ ನೇಮಕಾತಿ ಅವರಿಗೆ ತಿಂಗಳಿನ ಎಲ್ಲಾ ದಿನಗಳ ಸೇವೆಗೆ ಅವಕಾಶ page 109. Immediately after when this proceedings were going on, directly the point. ಬೆಂಗಳೂರು ನಗರ ಸಾರಿಗೆ ವಿಭಾಗದಿಂದ 64 ತಾತ್ಕಾಲಿಕ ಅವುಗಳ ಹೆಸರ ಮೇಲೆ 790. Kindly come to the next document. 4/11/95. In 4/11/95, the probation order is issued, page 111.
Yes.
All these persons will not have come either on reference or as a probation by way of this. They're all aware of it, the initial appointment. So therefore, they cannot say because the initial appointment, they're aware of it. So they know that when they got into the conversation, they want it to be on record so that they can claim themselves.
Yeah, see, even otherwise, they would be claiming under that head itself. That is the date of appointment. When was the date of appointment?
Probation.
1993, the initial appointment. No,
But
they may not be entitled. They may not be entitled.
They're not entitled, but they were aware of it, that they are not entitled. Only when they are about to retire, they are not entitled.
Now they are not working right now.
Most of them are.
Okay.
If I were not, that is the data. But every employee knows that the date of information is date of information. They did not know. But now, when not after a lapse of 22 years, now they cannot buy a show. My seniority published in the right publishing.
No, they say they are not agreed by the publishing of your seniority list of the year.
And now we're not for all purposes, but they are from 93, that is also 60, but whenever wherever the vacancy arose. Now we're not, if they are agreed by the probationary order, they should have questioned. That's saying that the vacancy arose at this point of time. Therefore, you have appointed me on this day. Because it's of no consequence to them, because if I give a day prior to 90, of no consequence. Unless they question and they cannot question in terms of addiction yet.
No, they have specifically made it clear that they are not placing their reliance on the appointment or the notification dated of the year 1992. They say they are not claiming seniority on basis of 1992.
They are claiming because otherwise, they are one more time the probation period.
No, now, though they say, according to your submission is, though they say their contention is they are not claiming seniority from the notification of the 1992, but their ground made out before this court, according to you, is that they should be entitled for seniority from the year 1993. That is their contention.
That they did not succeed. Annexion A order. Annexion A. That is. In fact, they are asking that annexion A will not. Annexion B, page 45, page 45. Annexion D. All these will. When I sought to release them, once it went on, lifting of the back was like.
Right.
Page 62. Page 62. Exactly the prayer they are. Read the preamble. Petitioners of petitions of fight. Ready to declare that the petitioners are regularly deputed permanent candidates face existing clear vacancy as per the Telecast corporation and to direct the corporation to utilize the services of the petition. They ask, this was rejected. But I
regularly
from the representation.
Just a moment. Regularly. So this was done in the year 1993. They have sought in the year 1992 itself.
They approached first, immediately on the beginning of the batch.
Correct.
By way of petition.
You understood.
These people came in because the back. So I took these only as more than employees. Only as this period of money to fund.
Yes.
So it was a large number.
Yes.
And if you're not sure, see, aspects of the yes. These were the stuff of that. When the recruitment notification, there were a large number of backup vacancies. Initially, we were engaged and appointed as a sanctioning subject to final selection. And by the time the state government had passed on, we were getting 1 year of service. Though we were looking at 4 years of service, satisfied all requirements. There was an abnormal delay, placing us on probation, subject to the terms and conditions of coordinated. Yes. Because it's difficult. your lordship, the entire language of the order, in respect of 56 contenders.
Yes.
Now, for me, not only 56, there are those who have come before the court and those who have not come before the court. 286 candidates are. And at this point of time, say that they want the initial date. Without the initial order, they have not been taken. So therefore, days but capital, the first prayer was not. In the second prayer, same prayer, what they saw in addition B, is therefore, they are only giving the assurance, and also taking each, the service is to come in employment and examining that. Despite knowing that they are not entitled to it. Systems about the entire discussion about the Friday and so I did not understand immediately because I did not understand it. And finally, I noticed this morning they gave me that Shama and when I was going to entry, I thought that 93. I thought your doctor could ask me why 93.
Yes. We dictate in the afternoon.
No, I altered the select list, the petitions in the select list for capital after the course of.
Correct. So they cannot make any alteration. That was the contention. Now that is in writ appeal. Confirmed. No? So then their contention was that you cannot alter or change the equivalent. ಹೌದು.
The equivalent qualification is filed an affidavit is filed with the state, stating that this course. That is one aspect. Second aspect is
You can make changes, Santana, that you can make changes. Or...
The state government is no
equivalent to.
How can you ignore the word? I have one more information. But 1 year course, 1 year examination. But that is just course, 1 year exam. But that I have made it in a chapter for the
If that is there, then you have very less chances, Mr. Sampath.
Comparing 1 year course marks with the 3 year course. That is the main thing.
But then if they say that equivalent to anta helidmele that
I have remind upon so many people now that she evaluation.
What will it?
Yes.
There was a condition below. That, like, if a candidate is applying for more than one post, they should give the order of preference. They cannot change it without later.
Correct. Oh, this matter was heard for a long time.
I will not, then, we changed it, but because the board, to the resolution, the board, found that there were candidates who were more meritorious.
Yes.
I think, in fact, your lordship got the key on the, all those records. Taking into consideration, you will not, but alteration is done after the issue of the evidence. And if it is the larger interest and if it is applied to everyone,
Correct.
that would be done. But that's,
Yes.
if your lordship, page 23, what petition?
With petition, this presented petition.
But one of the issues,
Yes.
ನಾಗರಿಕ ಎರಡು ವರ್ಷದ ಕಡ್ಡಾಯವಾಗಿ 2 ವರ್ಷ
You are reading page number 33, no? Yes.
ನಾಗರಿಕ
Yes, yes.
ಕಡ್ಡಾಯವಾಗಿ 2 ವರ್ಷದ ITI ಕೆಳಗಡೆ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಅಥವಾ ತತ್ಸಮಾನ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ clarification issue by the government, state government, saying that the board will not that remember that so is authority competent authority. One and secondly will not make it more confirm on the board will not directly
Yes.
they find an affidavit. I'm stating that the entire sometime to them, 2003 days. To show that for the reason they carry. So this was noticed by the corporation. How the candidates that where do we get 1 year?
Correct.
When the court system is 1 year.
No, according to them, you could not have changed the. So you have not changed the basic construction. What you have changed is only the equivalent qualification, which is equivalent.
That is the regulation. What
Regulation number?
What is the page number? What is the page number 10? Anything. Page number 10. You also put the come to the definition clause. The first page is there.
Page number.
That's the title and page. Title and first page where the definition clause.
Yes.
What is that? Serial number 11.
Serial number 11. Where do you get it? Page number. Page number. You are reading the page number. Page number 10. Then there is male, female, men, women. Sorry. Equivalent qualification. This is the definition. Preliminary definition, first page one.
Or examinations, right, in respect of category. Then, you know, if the women is, you know, the hospital authority is state law.
He said,
But I find that in, you know, it's not necessary.
yes.
Here, the state government also mentioned. Taking that, the course is only one.
You keep this regulation along.
Yeah.
Okay.
Graduates.
Ah, yes, please. Is this matter day after tomorrow? Day after tomorrow for further review. Yes. Yes, yes. Korea. Yes, Korea.
Maybe there.
Yes,
I'll find one more.
yes. Yes, Mr. Prabhakar. Mr. Subramanya. ಯಾವ್ದಿದು ಪಾಠಗಳು? What is this pattern matter? ಯಾವಾಗ hear ಮಾಡಿದ್ದು? ಇನ್ನೂ ಹೊತ್ತಾಯ್ತು. Into Pasora 33 C2 na? Yes. Pasora. Yes, Mr. ಬನ್ನಿ ಹರೀಶ್ ಭಂಡಾರಿ ಅವರು. Retirement. Retirement or resignation. Now ನೀವು ತಕ್ಷಣ I just looked into the regulations. Regulations ಹೇಳ್ತದೆ that 1 month notice ಕೊಡಬೇಕು by the and you have to accept keep that 1 month pending. ಆ ರಾಮ್ ಗೋಪಾಲ್ ನೋಡಿದ್ರೆ ಬಲರಾಮ್ ಗುಪ್ತಾ. This is that Balram Gupta case where it says you don't take this resignation immediately. ಅವ್ರು ಕೊಟ್ಟಿದ ತಕ್ಷಣ ನೀವು ತಗೋಬೇಡಿ ಅಂತ. Give them breathing time. And in the meanwhile, if they give any withdrawal of that resignation, you have to take it. That is how this Balram judgment says. Your regulations say ಇದೆಯಲ್ಲ. Back wages ಬಗ್ಗೆ ಹೇಳಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ಭಂಡಾರಿ? Back wages ಎಷ್ಟು? 25% ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನು ಕೊಟ್ಟಿಲ್ಲ? From when to when you are entitled? 2013 to 2010 to 2000? Is entitled for back wages, alva? Is it not?
Sir,
Please take. You're not claiming. Not work, not entitled for wages. But let him get He'll take your submission that he is not claiming the back. ಅಲ್ಲ salary ಆಮೇಲೆ ಅಲ್ಲ ಆಮೇಲೆ after the reinstatement.
By himself, it will be that there is within immediate effect.
ಅಲ್ಲ ಇಮಿಡಿಯೇಟ್ ತಕ್ಷಣ ಹೇಳಿದ್ರು ನೀವು ತಕ್ಷಣ ತಗೋಬಾರ್ದಂತ ಎಂಪ್ಲಾಯರ್ ಶುಡ್ ನಾಟ್ ಟೇಕ್ ತಕ್ಷಣ though he says it is to be taken takshana, you should wait because the employee is given 1 month's breathing time. Correct.
One month or whatever.
No, we can understand now, but now that he is superannuated, Mr. Bandari. He is already superannuated.
Yeah, and this type of cases, the person.
You can understand. We'll say that he said that he doesn't claim these back wages. Now then we'll say no work, no pay. He's entitled to Allah. That's all. WP 39626, which is the first writ petition in Kodu? Whose petition is first? Both of them have filed the same. 396926 of 2016 is preferred by the. Preferred by the corporation. Preferred by BMPC, wherein referred to as corporation, and WP 57104 of 2016 is preferred by the workman, assailing the legality and correctness of the award passed by the Labour Court in reference number 4 of 2014, dated 28 August 2015, wherein the Labour Court by the impugned award directed the corporation to reinstate the workman into service to its original post with continuity of service without back wages. Continuity of service ಎಲ್ಲ ಇದೆಯಲ್ಲ consequential benefits. Next. He was working as a driver. The workman joined the services of the corporation in the year 1986. For personal and domestic reason, the workman had submitted his resignation on 23/1/2010. And before his resignation was accepted, the workman had submitted a representation and the same was withdrawn by the workman. This being so, the workman once again submitted his resignation on 8/3/2010. And requested the corporation to permit him to deposit the amount for acceptance of the resignation less than a month of notice. Less than a month. The order of the corporation accepted the resignation of the workman on 12/3/2010. The workman submitted a representation to withdraw the resignation to the corporation on 23/3/2010. The authority the corporation issued an endorsement stating that there is no scope to withdraw the order of accepting resignation. Aggrieved, the workman raised a dispute before the conciliation office, and the matter was referred to the labor court for adjudication by the appropriate government. The claim statement was filed. The workman contended that, kindly be seated. The workman contended that Sarah, where is your claim annexure?
Shari was my.
Nimda, Aurga.
Another name is Shari. 322 hours.
What is your main ground raised in your claim statement? Contending that contending that the contending that the corporation has not accepted the resignation as per the circular dated 5/10/2000, 5/10/1990. Further, the workman has withdrew his resignation on 18/3/2010. The main contention of the workman was that the circular which was issued on 5/10/1990 as a procedure to be followed in respect of acceptance of resignation, and the circular contains four clauses under which a resignation should be accepted. On notice, the corporation appeared and filed their order inter alia, denying the claim state and contending that the contending that the questioning the validity of the order of the corporation accepting the resignation was not justified, as the workman had submitted his resignation, contending that his resignation to be accepted with effect from the date of submission, and the corporation has accepted the resignation of the workman without waiting further, as the resignation indicated that his resignation has to be taken forthwith. The corporation denied the entire amendments made in the claim statement. The labor court, by the impugned award, held that the resignation did not specify future date. The labor court by the impugned award held that at the time of accepting the resignation, the accepting authority did not follow the guidelines of the circular dated 5/10/1990, marked at Exhibit M10, and without considering the circular guidelines, the accepting of resignation was not was not appropriate, and by the June award directed the corporation to reinstate the workmen into service to its original post with continuity of service without back wages. Then a counsel appearing for the corporation would contend that the workman had submitted his resignation on 8/11/2000, 8/11 alva, 8/11, 8/11/2000. And that is first one. The workman has submitted. Yes. Which is the judgment you have relied? Krishna, right? Jitendra Kumar Soni was relied. Main contention is there. Then the counsel for the petitioner would be reiterating the grounds of in the appeal in the petition papers would mainly urge that the resignation submitted by the workman clearly indicated that his intention to resign from the post immediately at any future date. And having not mentioned but specified any future date, the corporation has accepted the resignation submitted by the workman. The resignation submitted by the workman is clear and unconditional, and the workman having not specified any future date, the intention to resign was clear, and the corporation has accepted the resignation submitted by the workman. It is submitted that in light of non-mentioning any specific future date, does not create any right in favor of the employee concerned to resist the acceptance of resignation. And the workman cannot place reliance on the clause A and B. Clause B and C, A and B, B and C of the regulation. Circular dated 15/10/1990. The contract learned counsel appearing for the respondent justifying the order passed by the award passed by the labor court and would contend that and draws the attention to the circular dated 5/10/1990. More particularly to clause number C of the circular and submits that if an employee intends to resign, he should give a notice of his intention to resign at least a month in advance. And the competent authority may accept the notice of less than 1 month if there are compelling circumstances warranting such acceptance. According to the learned counsel, there were no circumstances compelling warranting such acceptance, and the corporation was not justified in accepting the resignation before the expiry of 1 month, and the same has been rightly appreciated by the labor court, which warrants no interference by the. Having heard the learned counsel appearing for the parties, the point that arises for consideration is whether the acceptance of resignation, by the corporation was justified in the present facts and circumstances, and the order of the labor court, and does the order of the labor court warrant any interference by this court? The the workmen joined the services of the corporation in the year 1986. It is not in dispute that the workman had on earlier occasion submitted his resignation, and the same was withdrawn by way of a representation which was accepted by the corporation. The This being so, the petitioner again tendered his resignation on 8/3/2010. And the letter of resignation, is that annexure? Second resignation. Have you produced? Who has produced on? Annexure B. Annexure B. Annexure B. At page number 14, which reads as under. Paragraph mark Madhu. It's that much. The workman stated in his resignation letter that his resignation has to be accepted forthwith. The corporation accepted the resignation by order dated 12/3/2010. The workman withdrew his resignation on 18/3/2010, indicating and explaining the circumstances in which he had opted for resignation. The accepting of resignation by the corporation made the workmen approach the labor court. As contended by the workman council that the guidelines under which the corporation has issued a circular provides the procedure to be followed for acceptance of resignation. It is contended that the procedure as prescribed in the circular has not been followed, and as such, the order of acceptance of resignation itself is invalid. The counsel for the petitioner counsel for the workman submits that the workman had withdrew the resignation and the corporation ought to have accepted the same. The circular dated 1990, more particularly clause C. Annexure B ನಲ್ಲಿ of ratification 5710. C and D. C and D reads as under. The A, B, C, D ಎಲ್ಲ ಹಾಕ್ತಾರೆ. And then mark emphasize only on C and D. Underline only. Emphasis supplied. ಇದರಲ್ಲಿ 1 month salary deduct ಮಾಡಿದಾರಾ? ಇಲ್ಲ. ಮಾಡ್ಕೊಂಡಿದಾರಾ? The corporation has deducted the 1 month salary when accepting the resignation of the workman. Clause C of the circular indicates that a resignation is effective when it is accepted and the concerned employee is relieved from his duty. Though there is an acceptance by the corporation in the instant case, the employee was not relieved from his duties when the workman had submitted his withdrawal of resignation. As stated supra, clause C and D specifically empowers the authority, competent authority, to accept the notice of less than a month if there are circumstances warranting such acceptance. The compelling circumstances warranting by the corporation to accept the resignation immediately. Nothing is forthcoming. No reasons have been stated by the corporation while accepting the resignation of the workman, other than stating that the resignation dated 8/3/2010 filed by the workman is accepted. In the absence of any compelling circumstances for the employer or corporation to accept the resignation within 1 month, the labor court was justified in setting aside, in holding that the corporation was not justified in accepting the resignation of the workman, and it was unjust on part of the corporation. The point framed for consideration framed by this court is answered accordingly, holding that there warrants no interference of the order passed by the labor. Then a counsel appearing for the workman would fairly submit that the workman does not claim back wages from 2010 till the date of reinstatement, as he has not worked during the said period. However, would contend that the workman is entitled for consequential benefits from the in your petition. Where is that paragraph? ಯಾವುದು? When did you? We have said about your writ petition. Your contention we have taken. Yes. No, this contention of yours is taken now, not other than that. Other contentions we have taken. In light of the order, in light of the resignation being held to be unjust. There is sufficient force in the submission made by the learned counsel appearing for the workman, and the workman would be entitled for the consequential benefits from 12/3/2010 to till the date of reinstatement. And accordingly, this court passed the following order. Writ petition 39626 of 2016 is hereby dismissed. WP 57104 of 2016 is allowed in part. The petitioner the workman is entitled for consequential benefits from 12/3/2010 till the date of reinstatement. And the rest of the order stands confirmed. Yes. Is that another judgment which I have written? Yes, learned counsel for the petitioner. Learned counsel for the petitioner has placed reliance on the following decision. Okay, which is that one more judgment you placed reliance on? Following this, yes, we pay that.
Then another one is also. 8973.
The M. Ramakrishna versus Management of Bharat Electronics Limited, Bangalore. Writ petition, which is this loss KAR 1995 part 1, yes, page 7. Yes, M. Ramakrishna. In 1997 is the State of Haryana and others versus Ram Kumar Mann, 1997 part 3, SCC 321. Next, ID Kaushik versus State of Haryana and others. In civil writ petition number 9108 of 1994, Punjab, the court of Punjab and High Court of Punjab and Haryana. Then, Ramakrishna ಆಯ್ತಲ್ಲ? Ramakrishna ಆಯ್ತಲ್ಲ? Respondent very happy. WP 6809 of 1995, Subramanya, son of K. Ramaya versus Managing Director, KSRTC. And another. Number. Before point for consideration, the decisions placed by the learned counsel appearing for the corporation is distinguishable and not applicable to the present facts and circumstances. The coordinate bench of this court in Subramani's case has held at para number 7 as under. The apex court in the case of Balram Gupta versus Union of India and another reported in 1987 supplement SSC 228 as held at para number 11 and 12 as under. Common point for consideration. Paragraph 4. The employer's acceptance of an employee's resignation is a formal act, and that does not equate to termination initiated by the employer. The resignation is a voluntary act by the employee, and the employer's role is primarily passive in this context. The employers typically require employees to provide a notice period before resignation can be accepted. If an employee fails to specify a notice period, the employer may have discretion in accepting the resignation, but cannot do so with immediate effect unless regulations allow it. As stated supra, the clause B clearly indicates the waiting period of 1 month, and if the waiting period of 1 month is to be relaxed, there has to be circumstances warranting. There should be compelling circumstances warranting for acceptance of the resignation. There is nothing forthcoming in the said acceptance letter by the corporation, and accordingly, the court, the point claim for consideration is answered accordingly against the petitioner, against the corporation. Nothing again. With one judgment upon the Baswaraj versus NWPS, Baswaraj Vidapha versus NWPS series. Although you couldn't upon them. Yes. It's in light of all the benefits of the workmen to be settled within period of 4 weeks from the date of release of this order. Yes, please, sir. 2 months. Ultimately, the workman has already attained superannuation. Council submission and petitioner council submits that the workman has already attained superannuation and he does not claim back wages. Very good. Between the Seniority petitioner of the corporation Hitendra Kumar Soni was Union of India versus Hitendra Kumar Soni, 2014, Part 13, SC. Yes. It could be entitled for the benefits from 1997, not from 92. Yes. From 2000, though the yes, Mr. Once the abeyance is declared, they are entitled. That does not mean that there would not be entitlement.
Even unless an order of abeyance was lifted, and that order of abeyance was not kept at stay or hold for the necessity or an handicap. Only the department was handicapped by virtue of the directions of this honorable court, which had to be implemented before taking into consideration the postings to be given to them.
Whether the order keeping it in abeyance,
Yes.
will they negate their rights until that has been
So for that, in many of the instances and many of the cases, this honorable court has held no pay for no work. So until and unless a person comes to that particular cadre or to that particular post, will he be entitled to have the benefits of that particular post with respect to submission?
Correct. Now, this order of 1997 was kept in abeyance. You did not make any efforts from 1997 to 2007.
My connection with
Your appeal preferred before the appellate authority was dismissed. The appellate authority order was not challenged. So you did not do from anything from 2000 till 2007. You kept the order as it is. You could not take, they were denied the benefits for the reason because of you. Is it not?
my submission to that particular ruling of the honorable court was that until and unless the earlier order of this honorable court was implemented to its fullest extent.
Correct. See, there was something to be done by your part. If it is kept in abeyance, would that negate their rights which they were actually entitled for? The order of abeyance is not absolute. It is not that denial. Once it is lifted, and when that order doesn't say anything, or they are not entitlement, order doesn't say anything, just lifts the order of abeyance. It means they would be entitled from the date of which the order of regularization was passed in the year 1997.
On this particular point, I had a with the officer concerned with the department, I had a detailed discussion on this particular aspect of their contention to the annexures, which are the subsequent annexures which are just we had to first shortlist, then take it when there was not
You
available.
were at your end, you were at relaxed end. You thought nothing will happen. You kept it long pending for nearly 10 to 13 years.
Unless social department welfare office, it's not based there, because it's a cycle. No, this is not with respect to one department. The other implementations and the other implications of that filling up the other posts and all. As your lordship is well aware that Pavitra 1, Pavitra 2, many of the aspects came in between. Then we had to take care of all that.
When the order of lifting of abeyance was passed, was there any modification? Was there any findings given saying that they are not entitled for after the order?
No specific, I would like to submit it in a plain manner, no such
Then
specification.
they are entitled.
No such specification was made. And to that particular aspect was the order of abeyance. The order was passed. In fact, order was passed. We do not deny it. Once that order of passing of that order, due to the subsequent order of this honorable court came, was placed before the director. Director says that the earlier order, let that order be kept in abeyance. That means until and unless all those aspects are fulfilled, the order comes to an halt.
It doesn't negate their right. It's there.
In that aspect, if they don't work in that cadre, or if they don't put in their work at all,
Otherwise, they are entitled for this. But it is.
that is the observation of the court. I can only place my records and convince this honorable court. Yes, it would be something,
But that would not negate their rights. That's all this court
but
wants to
it
say.
would almost like opening like a Pandora's box would be my submission. There are almost 86. And that too, they were not kept.
Your first instance when you made this submission, this court was convinced that once there is
I stand with everything and able to convince the court on that particular.
now after reading the paper, this court is of the opinion that once the abeyance order has been lifted, they are entitled. When in the absence of any findings of that order in the order stating that they are not entitled.
For the sake of convenience, may I put this, or else put a question to myself. A person in an appeal filed by us says that.
No, they don't dispute that. They never dispute that abeyance order.
If they don't dispute the abeyance order
That
or
does
the
not
effect,
give them, that does not disentitle them of their rights. How can you say that they are not entitled for their rights? Which is already confirmed in the year 1997. The abeyance was kept so that other rights would be cleared. Now, once the rights have been cleared, they would be entitled.
we put it this way, madam, for the sake of convenience, I would just put it up. The probation period. The probation period for a person is almost 2 years or 3 years fixed up. Due to various reasons, the probation of a person is fixed after 5 years or 6 years. Can a person say that until and unless probation period is completed and confirmation is made, antedated he is entitled for this particular period?
That is not the circumstance.
This is equation. I'm just put it across as part of my argument.
There is a suit for recovery of money.
Yes.
Suit is decreed. The rights have not been established. Perhaps there is other suit. So they say this keep this order of recovery in abeyance till the rights have been determined. Once the rights have been determined, there, please give them that amount. So once the right has been determined,
Rights are determined. When that the rights get determined, final stage.
when it is determined, does that right of recovery of amount would go away? No, it stands. When the rights have been determined, they would be entitled for all the benefits which has been given under that decree for recovery.
The rights are determined.
There is no taking away of their right.
The rights gets determined only after
No,
the abeyance order is
no, no. Will you say that the rights would be determined only in the year 2010? So the decree or the interest which has accrued in that recovery suit of the year 2007, they would not be entitled. That would not be.
No, to that aspect.
Well, Mr. Consul, let your colleague, your senior argue.
That particular aspect, my lord, I would like to submit this way. That decree, money decree is made out in the year.
So until that rights are determined, we'll keep this order in abeyance. This is the order which we usually pass. Keep the order in abeyance. Once the rights have been determined there, you will be entitled for all things.
But if there are certain consequential things which had to be fulfilled.
There's nothing in the order which says so. Is it not? Well, yes, you have to say something. Mr. Consul, you have to say something.
I had to play, I had some to certain judgment, until and unless the things are completed. Brother, I have
You find that? You appear for whom? Who are you?
Chamundeshwari.
Who are you? Who is Chamundeshwari?
The Hemavati Sakai Shastani has been taken over by Chamundeshwari.
You sail along with them.
Please, Your Honor.
They sail along with you. Yes, what is this you want to say? This is a proposition of law regarding 33C2. Until it is determined or it cannot be adjudicated under 33C2. But now this is already adjudicated. Abeyance is there, order lifted, given to them. Very simple. Abeyance order was there, lifted, given.
The order of abeyance was 3rd June 1997. For a cost of repetition, if you got it, case will be page
3/6/1997.
3/6/1997.
Yeah.
For a moment, if your lordship bears with me, maybe it is cost of repetition.
Yeah.
I put in my last effort on this.
What is that?
Your lordship is operative portion. Page number 67.
Yes.
The respondent factory shall regularize the services eligible petitioners against a permanent regular post. Fact, full stop. The respondent shall strictly follow the roster for reservation of post. Read this second part of the order. Give its life I would like to sum it up and leave it at your hands. The second portion is also important.
When did you do that?
That is 2007.
Why did you take so many years? So you had the benefit of that abeyance order. Now you want to say you took so many 12 years, 15 years to do all this work, and now they are not. If you would have done in the year 1997 itself, what would have happened?
This was in the year 1997, madam.
Ah,
The order of this honorable court comes in the year again
same time.
1997. Then all our efforts
It took
starts
nearly
from the
12 years, 13 years to do all this exercise, and you are depriving them of those all benefits.
on the last order, if your lordship please to appreciate how many efforts we have made that we were not able to reach out to the candidates. We have to write it to the social welfare department. Social welfare department had to give their, because we had to both the things to be complied with here. Because it was not a single portion of the order.
If at all the order was set aside for something different, it's not set aside. It is only kept in abeyance.
Kept in abeyance for the second portion of the order to
So
be
you
completed.
say once it is lifted, it applies only from 2007, not from 1990. That is your contention.
My respectful submission will be 2007 because the second part of the order is also most important. Of page number 67. Second part of the order, second portion of the order is also important here.
Yes, then the Kane Commissioner felt while lifting the abeyance order, no, they are entitled for. Did they say they are not entitled from 1997 to 2007?
It only says at page number
So
122.
there it goes.
ಕಾರ್ಖಾನೆ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳು ಭರ್ತಿ ಮಾಡುವ ಕ್ರಮ ವಹಿಸುವ ಕಾರಣ ತಾವ ಅರ್ಪಿಸುವಂತ ನೀಡಿದ ಅಭಯನ ಭರ್ತಿ ಮಾಡುವ ಕಾರಣ
Abeyance order ಏನು ತಾತ್ಕಾಲಿಕವಾಗಿ kept, has been kept, and that has been lifted. Now you are entitled to. If you think in that point of view, they are entitled to. Was it?
Then the question mark and there.
Yes, sir.
Yes.
You have not challenged it. You have not challenged the order. You only sail along with that. What is that? Huh? What is that? Ah. Annexure? What is that annexure, Arman? That is your agreement with this petitioner. Now you are liable to pay. Who is liable to pay? They have to pay.
Page number 121. Fourth line of the order of the crane director. Maybe not, it's only 8 lines order. Page number 121. ಶ್ರೀ ಚಂದ್ರೇಗೌಡ ಮತ್ತು ಇತರರು ಹಾಗೂ ಶ್ರೀ ಎಂ ಕೆ ಗೌಡ ಮತ್ತು ಇತರರು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಏನೋ ಅವರ ವಿರುದ್ಧ ಆಯುಕ್ತರ ಅಭಿವೃದ್ಧಿ ಹಾಗೂ ಸೆಕ್ರೆಟರಿ ನ್ಯಾಯಾಲಯದ ದಾವೆ ಅರ್ಜಿ ಸಂಖ್ಯೆ ದಿನಾಂಕ 3/6/97 ಆದೇಶದಂತೆ ವಿಲೇವಾರಿ ಮಾಡಿ ತದನಂತರ ಸದ್ಯ ಆದೇಶ ಜಾತಿ ಪಂಗಡ ಅಭಿವೃದ್ಧಿಗಳ ಬ್ಯಾಕ್ಲಾಗ್ ಭರ್ತಿ ಮಾಡುವವರೆಗೂ ಅಬಯನ್ಸ್ ನಲ್ಲಿ ಇಟ್ಟಿದ್ದ ಆದೇಶಲಾಗಿದೆ.
That is what they say.
ಭರ್ತಿ ಮಾಡುವವರೆಗೂ ಉಲ್ಲೇಖದಲ್ಲಿ
ಮಾಡಿದ್ಮೇಲೆ they are entitled to.
ಉಲ್ಲೇಖ ಪತ್ರದಂತೆ ಕಾರ್ಖಾನೆ ಈಗಾಗಲೇ 34 ಹುದ್ದೆಗಳು ಭರ್ತಿ ಮಾಡಲಾಗಿದೆ. ಉಳಿದ 10 ಹುದ್ದೆಗಳಿಗೆ 3 ಬಾರಿ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿದ್ದರು ಸಹ ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳು ಲಭ್ಯವಿರುವ ಕಾರಣ ಭರ್ತಿ ಮಾಡಲಾಗಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಈ ಸಂದರ್ಭ ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಅಧಿಕಾರಿಗಳನ್ನು ಸಂಪರ್ಕಿಸಿ ಅವರ ಮಾರ್ಗದರ್ಶನ ಪಡೆಯಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಹೇಮಾವತಿ ಸಕ್ಕರೆ ಕಾರ್ಖಾನೆ ಇಲಾಖೆ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ವರ್ಗಗಳ ಎಂಪ್ಲಾಯೀಸ್ ಅಸೋಸಿಯೇಷನ್ ಅವರು ದಿನಾಂಕ ಸೋಲಿಸುವುದು ಈ ಕಚೇರಿಗೆ ಪತ್ರ ಬರೆದಿದ್ದು ಕಾರ್ಖಾನೆಯ ಹಾಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುವ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಪಂಗಡ ನೌಕರಗಳ ಕಾಯಂಗೊಳಿಸಿರುವ ಬಗ್ಗೆ ಕೋರಿರುವ ಮನವಿಯನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಕ್ರಮ ವಹಿಸಲು ಸೂಚಿಸಿದೆ. ಕಾರ್ಖಾನೆ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳು ಭರ್ತಿ ಮಾಡುವ ಕ್ರಮ ವಹಿಸುವ ಕಾರಣ ದಾವಾ ಸೋಲಿಸು ನೀಡಿದ ಅಭಯನ್ಸ್ ಆದೇಶ ತೆರವುಗೊಳಿಸಿ ಹಾಗೂ ಪ್ರಕರಣದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಮುಂದಿನ ಸೂಕ್ತ ಕ್ರಮ ಜರುಗಿಸಲು ಸೂಚಿಸಿದೆ. This is the final order in accordance with law.
Against whom the petition was filed? 33C2. Application was filed against respondent number 7. Respondent number 7.
It's the petitioner as well as respondent numbers.
Did you enter into an agreement with them? Yes. So now who has to pay? The petitioner. So nothing, respondent number 7 has very limited role.
For that particular period, the still agreement was not committed to.
It was you. Till 1997 to 2007, you were assailing the.
In order as security, we have just placed 10 lakhs.
What is the total amount which we are, how much we have to pay?
In this order, I would like to point out one more error. Ramchandra had already taken away his right, but still there is an order in his favor also. Gopal
He has taken his right. What do you mean? He has taken his, he doesn't claim.
He does not claim, he makes before they file some memo.
So who is that petitioner number?
The respondent, that is applicant number 1, Ramchandra,
Case number 1.
before the trial court. Then Gopal, applicant number 3. Before this honorable court, he withdraws his right.
He withdraws here.
Before this honorable. The another 3 are left out, that is M. Chandregowda, J.D. Ramakrishna, Nagegowda, and Ramesh. 4 are.
Any respondents? That is appellant number 3 goes. So Sri Ramchandra, MN.
Ramchandra and Gopal, that is the respondent number 1 and 3.
Both are not. Applicant number 1 has already withdrawn before the labor court. And then Gopal before this court. So Ramakrishna, Nagegowda and M.H. Ramesh. They are the 4 of them. Assailing, kindly be seated. Assailing the legality and correctness of order dated. 4/2017 in application number 1 of 2013 on the file of the presiding officer labor court at Chikmagalur, herein referred to as labor court for sake of convenience. Second country, wherein the application under section 33C2 of the Industrial Dispute Act 1947, 90 Act for was allowed, and responding number one, no, not Ramchandra, right? Respondent number 2, respondent number 2 to 6, right? Gopal was withdrawn by before this question. 2 to 6 was held. And to Ramesh. They say petitioner number 1 also is entitled that Ramchandra anta ಹೇಳಿದ್ದಾರೆ.
Ramchandra, the honorable
However, he was granted.
that was what I said, that.
Where is that memo? Memo, where do you get? Yes,
Case admitted, no fine or behalf of the petitioner is allowed. Usually, as regards arbitration, then chance can be take copy of one purpose. Even though that was in the order sheet, while passing the final order,
respondents. Respondents 1 to 6 and covered, all the respondents. Respondents 1 to 6 were held to be entitled for back wages from July 1997 up to 2007 with 9% interest per annum from the date of application until its realization. Application was filed by respondent 126 under section 33C2 of the ID Act, contending that the Commissioner for Cane Development and Director for Sugar has passed an order dated 1997, directing the hold on, 1997, directing the petitioner to regularize the services of the respondents 1 to 6 against permanent regular post, and the petitioner should follow roster system for reservation of post. And and sought for monetary benefits from 1992 along with interest at the rate of 18% per annum. The petitioner filed objections to the said application, contending that the respondents 1 to 6 are not eligible for monetary benefits from 3/6/1997, as the order was kept in abeyance by the Commissioner of Clean Department, and the same was lifted only in the year 2007. And as such, they were not entitled for the monetary benefits for this interim period when the order of regularization was kept in abeyance and sought for dismissal of the application. Before the Labor Court, respondent number 1 to 6 adduced evidence by examining themselves as PW1 to PW6 and marked documents as exhibit P1 to P12. On the other hand, the petitioner man examined one Sri Govinda Gowda as RW1 and marked documents at exhibit R1 to R28. The Labor Court, by the impugned award, allowed the application, holding that respondent number 1 to 6 are entitled for back wages from July 1997 up to 2007 with interest at the rate of 9% from the date of application until realization. which reads as under page number 97. 158. That's the petition number 1. But it is brought to the notice of this court that petitioner number 1 before the applicant number 1, Sri Ramchandra, had filed a memo seeking to not press the application filed by the petitioner number 1. And accordingly, the memo was accepted and the petition was dismissed as not pressed insofar as applicant number 1, Ramchandra, was concerned. The respondent number 3, applicant number 3 before the labor court has filed a memo before this court seeking to withdraw his claim in his respect, and accordingly, the petitioner number 3, the respondent number 3, applicant number 3, has been deleted from the present petition, and thus the petition survives in respect of respondent number 2, 4, 5, and 6. Learned counsel appearing for the petitioner, reiterating the various contentions raised in the writ petition, would mainly contend that the respondents are not entitled for monetary benefits as directed by the Labour Court from 3/6/1997 as the order directing regularization of the respondent into service was kept in abeyance, and thereafter the order of the Commissioner, Cane Development, was implemented on 31/5/2007, and the respondents are not entitled for any wages from 3/6/1997 to 31/2/11. When was the order of lifting? 11/5/2007. 11/5/2007. Respondent number 6, by filing statement of objection, has supported the contentions raised by the petitioner and has been contended that the petitioner had decided to lease out the factory and obtain necessary approvals from the government of Karnataka in this regard. And the respondent number 7, not 6, 7, being the successful bidder, was provided with the lease by the petitioner. And the period of lease has commenced from 26/10/2007 for a period of 30 years. The respondent number 7 contains that there is no direction by the Commissioner of Cane Development and Sugar to regularize the service of the respondent 1 to 6 with effect from 31/1992. Neither the lease as entered and the lease with the respondent number 7 was entered only on 26/10/2007 and not prior to it. Respondent number 1 to 6. Respondent number 1 to 6 have filed their objections, and in supporting the objections filed, learned counsel for the respondents, applicants submit that the Commissioner for Cane Development has passed an order regularizing the services of the respondents 1 to 6 on 3/6/1997, and the respondents are entitled for back wages from 3/6/1997. It is contended that the Labour Court, by appreciating the entire material placed before it, has directed back wages from 1997 till the lifting of the orders, and the same does not warrant any interference by this court, and sought for dismissal of this. Having heard the learned counsel for the parties, the point that arises for consideration is whether the order dated 3/6/1997, 3/6/1997, whether the order of abeyance dated 3/6/1997 by the order dated, whether order of abeyance by the Commissioner for Cane Development would disentitle the respondent 1 to 6 seeking monetary benefits, when the Commissioner for Cane Development has regularized the services of the respondent 1 to 6 on 3/6/1997. 3/6/1997. The respondent 1 to 6 filed petition under section. I think this court has carefully considered the rival contention, urged regular counsel for the parties, and produced in evidence. The respondents 1 to 6 filed a petition under section 10 subclause 1E and 2 of the Karnataka Cooperative Societies Act to declare them as a permanent employees of the petitioner factory by contending that they were appointed with effect from 30th January 1992, and they are discharging the duties, and they come under the categories of permanent employees, and that the petitioner established is a factory as per section 2J of the Industrial of the ID Act, and the respondents are workmen as per section 2A of the ID Act. Respondents 1 to 6 and 10. The said dispute was allowed by the respondent, was allowed by the Commissioner in Development, Director of Sugar, by order dated 3/6/1997. The said order directed the petitioner to regularize the services of the respondents 1 to see against the permanent regular post, and that the petitioner should follow the roster system for reservation of the said post. The relevant portion of the order passed by the Cane Commissioner is reads as under page number 29, marked portion. The appeal was preferred by the petitioner in appeal number 494 of 1997 before the appellate tribunal. The appellate tribunal, by the judgment, by the order dated 22/2000, dismissed the appeal preferred by the petitioner. The But after the raising of abeyance, you should have challenged that order. when the order was lifted, no, when the order, if the appellate tribunal said as there is an order of appearance, this petition was not maintainable, or petition has to be dismissed. You should, after the order was lifted in the year 2007, you should have said this, I'm challenging the order in light of the abeyance being lifted. That has not been done by. So then that remains as though it is unchallenged. Yes, where is the tribunal order?
Order start from 81. If the lordship, tells me, agreements coming in, says that the abeyance order is for a specific reason. It is valid, and because there is an issue also on that abeyance order being passed.
The appellate tribunal dismissed the
Court said that, issue was also based on keeping the order in abeyance, sustainability of that. Page number 92 is the issue.
tribunal framed the following points for consideration, page 108. While answering point number 1, the labor court, the tribunal observed that the abeyance order issued by the director is for a limited specific purpose of filling up give a finding which reads as under extract one, page 109, mark portion. The it did not accept the abeyance order to be kept in abeyance. It did not accept the contention of the respondent. Come to para number 109, page 109. We also do not find with the arguments raised by the counsel for the respondents that the appeal is not maintainable on the ground that the director has kept his order under abeyance. Because the abeyance order issued by the director is for a limited specific purpose of filling up the. So it doesn't interfere on, it passes an order on merits. ಏನಾಯ್ತು extract ಮಾಡಿದ್ರ the tribunal arrived at a conclusion that the abeyance order issued by the director is for a limited specific purpose of filling up the backlog vacancy, and therefore it did not find any valid grounds to interfere in the with the lower court orders, and by the order dismiss the appeal preferred by the petition. The order directing regularization in favor of the respondents 1 to 6 has attained finality way back in the year 2000 by the appellate tribunal. The term abeyance inverted comma refers to a state of temporary inactivity or suspension. The apex court has time and again held that when an order is kept in abeyance, comma, it does not negate the rights of the affected party. For instance, in the cases of recruitment or disciplinary actions, the right of the employees may still be preserved until the final decision is made. The apex court in the case of Prakash Bhagwani versus Sanmati Food Products Private Limited, Sagar. 2. Fearless Inn versus First Labour Court. 3. Rangarajan versus Union of India, State Secretary. The entitlement of benefits under regularization is often contingent upon the specific terms of regularization order. If the order is lifted, comma, the employees be entitled to benefits from the date of regularization order, depending on the context and stipulations outlined in the order. The affected workman indeed would be entitled for the benefits from the date of regularization once the abeyance is lifted, the principle being, while an order is in abeyance, the rights of the employees are not extinguished, but rather held in suspension. The apex court emphasized the decision of the apex court stated supra emphasized that any benefits that are due should be honored once the regularization is formally enacted. The decision stated supra indicates that the courts should incline towards protecting the employee's right during the period of uncertainty, during the period of administrative uncertainty. The order of the cane commissioner, the order of the commissioner for cane development was implemented on 31/5/2007. That doesn't mean that there is any impediment for the petitioner to regularize the post of respondents, and the petitioner was negligent in implementing the order passed by the Commissioner Cane Development. The Labour Court, analyzing the entire oral and documentary evidence, has held that the respondents are entitled for regularization of services from 3/6/1997. The perusal of the impugned order does not suffer from any perversity or illegality warranting any interference by this. And the point framed for consideration is answered against the petitioner and in favor of the applicants, and the score has the following order. The writ petition is dismissed. The impugned order passed by the Labour Court stands confirmed, making it clear that the order of regularization dated 3/6/1997 is to be implemented in respect of respondents numbers 2, 4, 5, and 6. You can calculate and give them, right? It is made clear that any amount paid by the petitioner to be deducted and paid to the respondents within a period of what was concurrent?
As well as during a seasonal period, they were paid their entire seasonal payment as per the contract.
You have to file it before the executing court.
An observation that the payment of entire.
Any amount paid, any amount already paid during the period of 3/6/1997 to 31/5/2007 to be deducted.
Yes.
To be deducted, and the balance entitled amount by the respondents to be paid by the petitioner within a period of
Calculation and all.
how many? We'll say 2 months, to be paid within 2 months. 3 months. 3 months.
Yeah, of course, because we will withdraw the amount with respect that.
You say that disperse that amount to them. No, it's already in deposit. We'll send it to the executing court. The amount in this deposit to be transferred to the execute, which is that in application.
Execution has not been filed with my instructor. Execution has not been.
They'll file in that only. Amount in deposit.
Can we put it back to the department?
Where should we transfer it?
Petitioner.
With labor code. Amount in deposit before this court pursuant to the interim order granted by this court to be transferred to the concerned labor court. Concerned labor.
Petitions which are dismissed before the labor court. Those aggrieved parties are before your lordship. Maybe this order will hold to.
No.
There are three petitions which are.
So we'll connect, you can move that to petitions. Once this order is released, after the order is released,
That is respondents in law.
so you can just show that order anytime. Please.
Disposal of that, those get disposed of immediately.
Correct. Now that after the release of this order, you can take the copy.
So the serial numbers may be adjourned today.
It's there today. Which are the serial number?
7 it was connected with it.
Then it's same order.
But they are the, only petitioners there. They were rejected before the labor court.
Correct. We have to pass a detailed order on that.
Vice versa, it goes
Vice versa. Which is that copy?
47, 1, 2. 47, 1 and 2.
47. All those, Sachin BS, huh?
The respondents in all the three matters. Now,
We have to say their petition is allowed. So we'll say that petition is allowed. Yes, yes. We'll pass a detailed order on petition allowed on top of it. Impugned order, 47 and 40. You can inform them. Yes. Inform 47 and 47.1. The impugned order passed by the labor court is said only one petitioner, right?
Three petitions.
So 3 petitions. Impugned order passed by the labor court is set aside. The petitioner are entitled for back wages from 3/6/1997. Same one, no? 3/6/1997 to in May and 5 of 9, 2007. Yes. 31, right?
More.
Your colleague is more into to argue this matter. Yes. Yes. So he was not leaving a senior in making any.
Matter with the quota number 2. If I am there, please assist the court on that.
But if he assists you, you'll get a good hand. Yes. 28 to 30 another sequence. You are seeking for an. All this matter at this with the petitioner counsel after 2 weeks. Muralidhar Peshwa is in the hospital. What happened to him? Petitioner counsel, so and so counsel submits that L. Muralidhar Peshwa is unwell. This matter after 2 weeks. Yes. 29. 29, Lakshman Rao is there. Yes. 29 is by Lakshman. It is 2012 matter, Mr. No, this is a matter court order. Where is the question of they filing their objections? 33C application is allowed. You're for the workman. Let us leave this matter as a final chance next week. Please not read. She will. When do you want? At this shop, so and so fast. Is this matter? Next week. Fine.
நாய்க்கிற ஓடே போட்டேன்.
Court officer? Court officer? Court officer? Kasturi. Sir? Sir?
ಏನಾಯ್ತು
Sir?
ಆನಂದ್ ಏನಾಯ್ತು ಇವತ್ತು?
ಯಾವ ಮ್ಯಾಟ್ರ್ ಸರ್?
ಕಿರ್ಲಸ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇವತ್ತು.
ಹೌದಾ? ಓಕೆ
ಹೌದು ಇಲ್ಲಾಂದ್ರೆ ನಾ ನೆನ್ನೆನೇ ಹೇಳ್ಬಿಡ್ತಾ ಇದ್ದೆ ಸರ್ ತಮಗೆ.
ಓಕೆ ಓಕೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಮನೆ ಬಂದಿದ್ರಲ್ಲ ನೀವು ಇವಾಗೆಲ್ಲ ಫೋಟೋ ತಗೊಂಡಿದ್ದೀರಲ್ಲ ಯಾವ ಪೀರಿಯಡ್ ಏನು ಅಂತ ಎಲ್ಲ ತೊಗೊಂಡಿದ್ದೀರಲ್ಲ. ಅದೇ ನೀವು ಇವರು ಗಂಗಾಧರ ಫೋನ್ ಮಾಡಿದ್ರು, ಆ ಪೀರಿಯಡಲ್ಲಿ ಏನೋ ಕೆಲಸ ಮಾಡಿದಾರಂತೆ ಹಾಂ ಮಾಡಿದಾರಂತೆ ಹೇಳಿದ್ದಾರೆ. ಹಾಗಾಗಿ ನೀವು ಅದು ಬೇಸಿಸ್ ಕ್ಲಿಯರ್ ಗೊತ್ತಲ್ಲ, ನೋಡಿದ್ದೀರಲ್ಲ ಪೀರಿಯಡ್, ಆ ಪೀರಿಯಡ್ಗೆ ಬೇಸಿಸ್ ಮತ್ತೆ
ನಾನು ಚೆಕ್ ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಇದೇನು ಯಾವಾಗ ಬರುತ್ತೆ ಕಿರ್ಲೋಸ್ಕರು? ಇವತ್ತು ನಾಳೆ 2 ದಿವಸ ಇಲ್ವಾ? ನಮ್ಮ ಮುಂದೆ ತಾನಿದ್ರು ಅವ್ರು ಸಿಟ್ಟಿಂಗ್ ಇದ್ದಾರಾ? ಏನ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇದೆ ನೋಡು.
Karnataka State Transport Corporation, Cadre and Recruitment Regulation 1982, and direct the corporation to regularize the services of the petitioners. This code, wide order dated 22/2/1993, passed the following order. Page number 69. Pursuant to the order passed in the above mentioned writ petition, the services of pursuant to the order, 401 workers were relieved, right? 400. Pursuant to the order passed by this court in the above mentioned writ petition, the services of 401 candidates, including the petitioners, were discontinued. Wide order dated 10/4/1993. The petitioners and the similarly situated candidates approached the state government seeking relief to make provisions for their appointment by invoking the provisions of Road Transport Corporation Act 1950. The state government issued an order dated 14/5/1993 directing to reinstate the temporary employees who belong to scheduled caste and scheduled tribe. And a report to this effect was directed to be submitted to the state government. Pursuant to the order dated 14/5/1993, the corporation framed guidelines to reinstate all 882 candidates conductors and drivers complete belonging to the scheduled caste and scheduled tribe. The respondent corporation appointed the candidates for the post of conductor and placed them on probation from the date of reporting to duty in terms of the order dated 4/11/1995. As per the guidelines issued by the corporation, the petitioners were placed as Badli conductors in the respondent corporation until their services were regularized in proportion to the vacancies arising from time to time, and hence the petitioners who were selected by virtue of the government order dated 14/5/1993 were placed below the selected candidates published in the select list for the post of conductor. The contention of the petitioner is that the provisional list of the conductors dated 18/3/2019 at annexure N, the candidates at serial number 219 to 744. Are selected candidates as per notification number 1. Are candidates in respect to the recruitment notification number 1 of 1992, or 1/92 in the year 1992, whereas serial number 745 to 929 are the candidates appointed pursuant to the government order dated 14/5/1993. That while assigning the ranking and placing the petitioner on probation, the petitioners herein who were working against the existing sanctioned vacancy and as such on par, vacancy, the petitioners have to be placed on probation immediately after the reinstatement and circular at Annexure M and has been and the circular reinstatement and the circular at Annexure N has not been followed by the respondent corporation. It is relevant to note that the petitioners are appointed pursuant to the government order dated 14/5/1993 and were placed below the selected candidates under the notification under the notification 1 of 1992 and the probationary dates of these candidates as were revised by the order dated. When was it revised? 28/6/19. Yes, 28/6/2019 by a final selection list. The selection list, the document for it. Learned counsel for the respondent has filed memo along with the final seniority list of conductors dated 28/6/2019, which is in compliance with the judgment of the apex court in Pavitra 2 and in terms of the guidelines issued by the apex court and also the state government. The provisional seniority list dated. Correct. Provisional list dated in terms of the guidelines issued by the apex court and also the enhanced the provisional list from 27/4/1978 to 15/5/2019 was prepared for the post of conductor and the same was published by the corporation on 29/5/2019, calling for the objections to be filed within 7 days. The petitioners have not filed objections to the provisional seniority list. The corporation considered the objections filed by the other employees within the stipulated period and published the final seniority list of the conductors dated 28/6/2019. The list was redone pursuant to the order passed by the apex court in Pavitra 2. And the names of the petitioners who were appointed pursuant to the direction of the state government dated 15/5/1993 has found place in the seniority list at serial number 1849/2006. 2006. The select list is of the select list of the corporation is in terms of the decision taken by the board to the order of the government dated 14/5/1993. The relevant portion of the resolution at Annexure H reads as under marked portion under page 100 on page 99 and article. Email, page 99. Page 100. The petitioner was issued with an endorsement was issued with a provisional seniority list 18/3/2009 and the final seniority list on 28/6/2019. the petitioner have accepted the provisional and the seniority list and did not file objections to the provisional list, whereby no final seniority list was published. And the final seniority list dated 28/6/2019 has not been challenged by the petition. The petitioner was the benefit available to the regular candidates appointed in terms of notification 1 of 1992. And the petitioners are seeking for seniority, which is on basis of the government order dated 14/5/1993. The appointment of the petitioners on probation was subject to the availability of the vacancy, as could be seen from the resolution dated 28/8/1993. The petitioner, the petition lacks merits, and for the foregoing reasons, the petition is liable to be dismissed. And this court passed the following order. The petition is dismissed. Then tell you that also, particularly. Suppression party. No, 13, suppression party. Just a moment, just a moment. No, 13, no. Other day you was not well, were not well. Why, what happened, Mr. Consul? You could have asked your colleague to appear today. Yes. Your relief for declaration. That's good for.
See, the Uttama and Chennai. Uttama and Chennai had a daughter dependent before the marriage. Exponent here. 20th.
You are the plaintiff. You claim to be the adopted son of Chennaiya. How many properties? One property. No, one property, which is a suit property.
Number 2A. Item number 1, schedule property 96/2, 1 acre 2 guntas.
96/2.
Or 1 acre 2 guntas.
21 guntas, 1 acre, 21 guntas. 68.
68/1 acre 34. Item number 3, that is survey number 54, 1 acre 14 guntas.
1 acre.
So it was granted in the year 1974.
1974 to Kuttama.
But according to the dependent memo, if some of the property was taken by the dependent by way of oral party, that is survey number 2A. 2 acre survey number 102 or B.
When were you taken into adoption?
Okay, it was 6 months old.
When was the year? So adoption is not proved.
Not proved.
You won't be entitled anything under the adoption.
No.
You are claiming.
Basis of the sale deed,
It is the sale deed. When was it executed? Anna, which was the property sold to you?
Only the item number 96/2, 68 68/1 and 54/1A.
Oh, these three properties you are,
1996, the estate at Uttama executed a will. 11/3/1996. Once my lord sale deed is executed by the Uttama, automatically my lord the will died.
but you claimed title on basis of the bill as well as the item number. No, you have,
Basis of the sale deed as well as the, but will is not good because already will.
you can't have only one part.
Two, three parts. Sale, sale deed, exhibit two.
Whether this Puttama had exclusive right to sell this property
Yes,
for
that is the
sale.
question. Because.
It could not come because her daughter was there when the Puttama was granted this right,
No,
occupancy
after
right.
partition it was granted at the end. 74 it was granted.
The child, defendant number one was already there in the
Yes,
family.
yes.
So then a
Yes.
grant in favor of Puttama would inure to the benefit of all the family members. And one more thing, the sale has been set aside.
It's by order of the Karnataka is confirmed with the sale deed. That is which I have produced before.
Which is the sale deed, so.
Petition. Because
Sorry, copy and copy them.
okay. Petition number. 19 of 2026, 16.
That Satnarayana.
Was allowed on my note the 7th July 2020. Only my lord, the first appellate court only on the ground that it was set aside. Therefore, my lord, the defendant has, the Uttama has no right over the shoot schedule property. Only on the basis of the DC order. DC order set aside by this honorable court.
It said the alienation is not, would not attract PTCL Act at that. But because it's an occupancy rights which has been granted, it is not the PT.
50% of the property already transferred to the defendant by oral partition.
Oral partition, one property put it down. What right you have to do that?
The court, my lord, clearly admitted at the time of cross examination, I have taken my share.
Allah, her taking share is one thing. Her right in this property is one thing. She must have taken a property in other properties. She must have taken a right in other properties. Reports ಬಂದಿದೆ. ಸ್ವಲ್ಪ TCR ಕೊಡ್ಬೇಕು.
Only on the basis of the DC order, the order.
Is Mr. Prabhakar? What is this?
For the statutory provisions of India. Second question, even assuming that we can invoke such, whether disputed question of tax will be drawing to 33C2 proceedings are analogous to execution proceedings. The brief facts of this case are the respondent was engaged as a diploma engineering trainee with effect from 10/1/2008. Your Lordship, I kindly refer to Annexure A, page 17. I'm only referring this case. This is the appointment order issued to the respondent with reference to your application and the subject to you had with us, we have pleasure in engaging you as diploma individual in our organization on 7/1 on the following content. Condition number 3, your first year of training will be assessed and based on your appeal. You will be based on second year training. Condition number 10, your attitude is not be relevant. 11, the company reserves right to alter the period of training depending upon your performance. The company reserves the right to discontinue or terminate the training at any time without assigning any reasons, without giving any notice.
Yes.
Now I request your lordship to kindly. There was annexed L page 59. During this period, this is a petitioner is a automobile industry. During this period, there was lot of recession in automobile industries. Austerity measures were implemented and certain benefits have also been withdrawn. At the outset, there are three priorities. As part of austerity measures to combat and the rapidly falling industry. The following actions have been taken to minimize the loss of our company. These first to support. Withdrawal of leave travel allowance, withdrawal of leave encashment, cancellation of variable pay for the first 2 quarters, suspension of a superannuation. Like this, several benefits have been withdrawn. At that point of time, the train is around 20 were undergoing training. They were informed about the problem faced by me. I told them, I am not in a position to feed work even to my permit work. Then you take a decision. I left to them. All of them, they have stopped coming to training from after 17/11/2008, including the respondent.
17/11/2008.
18/11/2008.
18/11/2008.
18/11/2008.
But this order of yours is 2009, 12th January 2009.
Order, engagement order is at
Correct. Their engagement order.
21/2008.
Now what you read, Annexure L, is at dated 12th January 2009. So before that, they relieved themselves from
Yes,
service.
yes. And even for my permit work also, there was no problem. The fact was, all automobile industries, the country, including my country, this is recession during that period. Therefore, the moral advice was given to the trainees. Take a decision whether to continue the studies. All the trainees, they stopped coming, including the respondent. Thereafter, it appears he got job elsewhere and he tendered resignation also.
How many respondents are there? Only one. Only one respondent.
Here, it's only one respondent. I am saying all the 20 trainees, including, he was one among the 20.
The other trainees have not approached the labor court. Other trainees have not approached the labor court.
The lordship is fine. The resignation letter, I took copies of actually page 20. With reference to the above subject, I tender my resignation for great training. I request you to accept my resignation and relieve me from responsibility. Accordingly, I accepted this resignation and I relieved him from 4/8/2009, Annexure C. Annexure C. Thereafter, he sent a legal notice, which is at Annexure D, case 22, claiming the claiming a stipend from 18/11/2008 to 3/8/2009. That is the date of resignation.
So why should,
According to him, the dispute is, according to him, he did undergo training till he came at resignation.
from 18/11/2008 to 3/8/2009.
Right, yes.
He issued notice only to that effect. Issued notice.
Thereafter, my lord, I sent a reply. I sent reply, which is a connection E. Para, I will just read para 2. Connection G, page 24. I'll just read para 2. Your client was engaged as diploma engineer training and based on order issued to him. He has reported for training on 7/1/2008. It is true that he was initially paid stipend of ₹4,500 for the first year, and he was to be paid ₹5,000 during the second year, provided he successfully completes training in August. It is incorrect to state that after completion of the 1 year training, he was moved on to the work for the second year as per the orders issued. He was provided with training in October 2008, as the company was functioning in good stead and the employees full time work. However, in view of the global recession settled to industries in general and the automobile industry, there was lack of order from the customer. Therefore, the company was not in a position to engage the services of the regular workman on consequently set back cases by the company. The trainees who were provided with an opportunity to undergo on-the-job training would not be provided with any other training. Hence, all the trainees in the staff were informed about the business downfall and inability to install after training if the situation becomes normal, with the assurance that they would be once again taken back and provided with facility. However, they were advised to take a decision in case they get better employment opportunities. Accordingly, the trainees generally, including your abstain from training effective from 17/8.
So their claim before the labor court is only from 18/11/2008 to 3/8/2009.
Yes.
Only that.
Now, that is the my
Your
defense
reply.
before,
Yes.
my defense before the labor court was, they did not undergo training from that period. In that connection, my lord, I have produced a document also. That is
Documents produced by you that he is not working for that said period.
I have produced
Negative.
master also saying that he did not work, he did not undergo.
Master
This is a disputed question of fact. First thing that the lordship the kindly turn to legal notice. Be clear in the second paragraph. Is particularly interested that the parent was selected with the appointment like diploma unit training. That is accepted. It's not involved. The fact that he did undergo training,
That is also
as a
not.
training is not disputed. Then I have also not disputed in my reply. Then I request your lordship to kindly come to annexure F, page 26. There are two. The applicant submits, there are two. The applicant submits that he was selected and appointed by the respondent as diploma unit training. Even his application also, he maintains that he did undergo as a training only.
No, you address. Allah. Mr. Subramanya, you address the grievance from 12th January 2009 till 2009. So he was, and you accept.
No, I did not terminate him. I did not terminate him.
But you issued a
My
notice
case is only that he accepted.
so that he is absent.
Yes, he accepted on knowing that even for permanent workers, he got taken on the job.
No, to
They
show
have
that
to, if there is no work even for permanent employees, where is the cost of undergoing on the job? No, my case is, he did not undergo training. In that case, the claim what he has made, he did not undergo. So that, I have produced, even, you are now. I have produced them. You are asking the kindly come to page 58.
W1, W2 is what? What is W1 and W2? That is not. Between the period, between the period of January 2009, when you issued your notice, you said this is the difficulties you
8 months payment I have paid.
have paid. So then,
I have paid. From there, from 18 he did not attend. He did not attend.
and to show that, how will you prove a negative
So
clear?
I have put master roll. Page 58. Page 58.
58 of
R6,
this,
R6 circular.
on 6th of
R6 to 15, counties of
Yes,
master
okay,
roll from being registered. It's not discussed at all. It is not discussed at all. He is marked as absent. He is marked as absent.
What is his name?
His name is Syed Sabirudin. Syed Sabirudin. He is marked as absent. I have produced original document before the level. It is not considered at all. Therefore, if it is disputed, that cannot be gone into the section 33C2. Number one. Number two, he himself admits that he is a trainee. Proud. How 33C2 is maintainable when he is a trainee? He is not a workman under such He is not disputing that he is not disputing his status as trainee. When he is a trainee, if we dispute that, and if he says that he is doing regular work, that is a matter for evidence. We can dispute that. And I have said in my application, that 33C2 is not maintainable.
Yes.
I take up that contention. Even as master roll, what I have produced, it is not at all considered. Assuming that section that is maintainable in this case. That should have been considered. Therefore, my points of view, we ought not to have invoked section 30 because and he is outside the purview of section.
Yes.
Number two, whether he has worked from assuming that he comes within the purview of section 2 years, assuming whether he has worked from 18/11/2008 to 3/8/2009, which is a disputed question of that. I have produced documents. So it is for adjudication, not for computation. It is not execution. It cannot come under execution procedure. And nowhere this master roll is considered.
When a resignation was accepted by you, did you say that he has not worked from so and so period? Did you say that?
General.
Alla, question, alla. Did you?
More training, including the response. But I did not permit them. The case is on that.
They remained absent.
Yes.
No, but then,
That's the.
one thing, when they give a resignation to you, you should have said that I'm not accepting your resignation because
Oh,
you
that-
had,
Uh,
you did not say that.
They kind of resignation.
So you were absent, you would not be entitled for it.
Because I only advised them knowing the position of my factory and realizing that.
How much is
not
it?
in single trainers.
How much is his entitlement? How much is his entitlement? How much is entitled to?
Account, not the first of the.
Pay that an amount
Why I am-
is it?
why I am- There are other trainings also. Who did not, they are not before your last. If they come again.
So we will not say anything on merits, pay that amount, some amount to them, settle the matter.
May not be a problem. Because if the order is passed in this case.
No, you can file a joint memo saying that, you can file a joint memo so that it will not be a precedent. Who has not approached, at a belated stage. If you pay that amount. See, if you pass an order now,
If you go to hospital before, definitely I will not agree.
no, what I'm saying is,
Not one case.
what I'm saying is, if at all this court passes an order now, saying that having accepted the resignation, having accepted the resignation, they are entitled for all this amount what they are entitled to, then many others will come. So instead of that, you settle the matter here.
You fix the enrollment.
ಈಗ ಬಂದಿದ್ದಾರೆ, all the while he was there before the court now, from 2009, from when he is,
I will make instruction.
tomorrow? Monday. No, Monday, Raja. Tuesday. See, it's a case where he would be entitled to, in the absence of anything in your resignation.
Yeah, which is what is
Correct.
not,
Understood.
not great for them. But,
We can think and
there are
sit across. and-
mostly private.
Lipton reserve, 2:30 ಗೆ ಯಾವ್ದಿದೆ? Ah. Ah. Yes, they have filed an application for recalling. Dismiss for default, Alba. We'll impose some cost on them. How much cost? How much cost will impose? Technicalities ನಲ್ಲಿ ಹೋಗೋದು ಬೇಡ. On merits we can consider it. Dismiss for default ಗೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕಂತ ಹೇಳಿದ್ರು? What is that exemplary cost according to you? What is according to you may not be. Where is he? If he comes, we'll recall with so much.
Someone knows officers.
Correct. They were not able. ಆಯ್ತು. ಒಳ್ಳೇದಾಯ್ತು. ನಾರಾಯಣ ಸ್ವಾಮಿ is happy now. Yes. Correct. Now that officer was present before the court that day. Good, you settled. Yes. That's why in today's matter also we told Mr. Subramanya to do something in this case. How much cost? Exemplary cost. Not for you, on the institution. How much cost? No humble for this United India Insurance. They take so much of insurance policy amount from us, so we will impose heavy cost. No, how much cost, tell us? Workers has to be given something. They are right. No, there is a right accrued in their favor long back 1 year. We are not going to hear you anything other than cost. Yes, how much cost? So much policy amounts will be there. So much amount premium you receive. Yes. So many claims are unsettled, or rather it is not even claimed. No accidents take place all the time. Yes, how much? How much? Only how much? No argument in this, no arguments for recalling. Both the consuls were there on record. Whether it is PB Raju or Janardhan, both of them should have appeared before the court. Both of them, what makes them not appear? See, I'll tell you one thing. When two names have been found in the cost list, we usually call the other consul and say, did you appear or did you give me that wakalat or am I appearing in that matter if the file is not found in the office? So that should have been done by them. Oh no, so how much cost?
This council passed away during COVID time.
But two consuls were there.
On the contrary, we have already given a couple of.
Insurance company, how much cost? Any amount of argument will not reduce your cost. You just tell the cost and we will tell you what cost you have to pay. No. You have to tell. How will impose cost? You pay it to how many worker or obne na? Pay him. He is there 1 year. He is thinking his order is already there in his favor. Then yes, or settle now. Let it be on the recalling application. Settle the matter. No. We are not hearing the merits until we recall the order. How much cost? How much cost? You pay some cost to him. 10,000. Yes. 10,000. No, 5,000 for a corporation. No. I-1 of 2024 is filed to condone the delay of 245 days in filing the recalling application. I-2 of 2024 is filed for recalling the order dated 13/2/2023. The present petition came to be dismissed for non-prosecution for non-appearance of the petitioner's counsel. The consuls were shown as PB Raju and Janardhan Reddy. The petition is by the United India Insurance Company Limited. The order of dismissal is passed way back in the year 2023. The respondents, a right was created in favor of the respondent, and the respondent assumed that the order of the labor court, the order of the CGIT labor court was confirmed in his favor. However, to see that on technicalities, the petition is not dismissed. This court deems it appropriate to recall the order dated 13/2/2023 and by condoning the delay of 455 days in filing the recalling applications, subject to the petitioner paying cost of rupees 10,000 to the respondent on or before. No, we are not imposing cost. This is made in light of the submissions made by the counsel for the petitioner. The cost which the court was inclined to impose at 25,000 is reduced to 10,000. Yes. Accordingly, I-1 and 2 of 2024 is allowed to be paid on or before date. By 17th? No, ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ದಿವಸ ಕಡೆ. By 27. on or before 27th. And file an acknowledgement to that effect. Yes. 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 You say your principles of natural justice. Yes. Now, this is a petition arising out of 33 2B, no? 33 2B. Seeking permission for confirmation of the dismissal order.
Not permission, my lord, it's approval.
Approval. Yes.
Sorry for me.
Which one in this matter? Yes, yes. How much time will you take? 15 minutes? 15. Both together 15 minutes. Yes. Senior counsel, after 15 minutes, will take up your matter. Yes.
Alright. My matter, this is my matter only, my lord.
Not your matter, not you, senior counsel. There is GK but over here.
Oh,
GK
sorry, my
but-
lord, I thought.
We will take your matter. We are taking up your matter. After your matter, we'll take up this. Yes. Murthy sir, we are taking up your matter itself.
Very well, my lord. Obliged.
1996 appointed. What was the misconduct? He was a conductor. He was a conductor. So this is not the corporate. He was working as a technician. Yes.
The first aspect, which I read my lordship consider that the order on domestic inquiry requires to be set aside, and patent requires to be divided. Lordship is not convinced to that aspect that I'm going to talk about.
Yes. What was your? Yes.
This is a case, my lord, where the management says that on one of the days of inquiry, the workman raised his voice.
Oh, ex parte.
But
But he was aware about this proceedings.
he was never aware. He was never proceeded. So, on that day, my lord, our version was we were never told that I'm this expert, nor was I in the inquiry at all. And I was never. Thereafter, I sure a letter to them saying that this a very long time of data what is that date. Then my lord, that letter comes back as returned, my lord, that I didn't cross examination. I'm not present for cross examination of the office, but not produced in the documents, I'm not allowed to give my lord the evidence, not allowed to make arguments, and the report comes to be passed, my lord. Now, I personally, my lord, to only see the last 3 paragraphs of the order, my lord.
Okay. This is the order on the domestic inquiry. Yes. This is 2674.
2674, my lords?
Yes, 2674.
Yes, my lord.
I request my lordship to turn to page number 109, my lord. At the very end of the petition, just the last few paragraphs in which the learned tribunal has appreciated, or according to me, misappreciated, the facts and circumstances.
This one. (109) is in writ petition
First petition.
44464.
No, my lord, I refer in 2674, my lord.
2674 doesn't find place here. The order is under the The order in challenge in 267422 is the domestic, is the final order. Is the final order.
I apologize, madam. Double four. In
Yeah.
44464.
4446. 4464 is the order under?
Domestic inquiry, madam. At page 109, my lord. 25 paragraph onwards, I'll read. On evaluating the oral and documentary evidence of AW1 and OW1, no doubt the evidence is not recorded in his presence. So much it was recorded before his co-employee who was appointed for his assistance. My lord, that is totally erroneous. No one was present for the workman. In fact, he has subsequent to him being placed ex parte, he is not aware he is being placed ex parte. So he files a letter, my lord, to the inquiry officer requesting for for the assistant to be given to him, my lord, a co-employee to be granted to him. That is evidence at the inquiry. I'll show my lordship those proceedings. So, my lord, this is a total misappreciation. There was no one present for the workman during evidence.
Because ground is on domestic inquiry.
Please, my lord.
No opportunity to you. Yes.
Then second, in 26, my lord, after the inquiry officer has passed an order to the findings, so also given second show cause notice to the charge sheeted opposite party, but he has not replied to the same only. I have replied in great detail, my lord.
Yes. The reply has been taken, not that he has not given any reply.
Yes. Then, my lord, 27. It seems that the inquiry officer had given a number of opportunity to the opposite party workmen to the adduce evidence who was working as technician since long time. But in the inquiry proceeding, he has stated that no opportunity was given. And that's total misappreciation of fact. In fact, if the proceedings themselves can be perused, my lord, on the fifth sitting, I'm placed ex parte. Thereafter, I give a letter. May I read the relevant, may I point out the relevant proceedings?
You have read it on the other
Please,
page.
madam.
You have read it wherein you said that he raised his voice and he left the meeting.
That is
at page 27.
That is without his signature, my lord, of course. Because they say he's walked out. Thereafter, there's not a
After walking out, where is the question of signature there?
my only submission is this. My learned senior counsel will rely on the judgment of this honorable court, my lord, saying that where he's placed ex parte and notice has been issued, then there's no question of violation of natural justice. My only submission is neither the order placing him ex parte.
Ex parte is when at the first instance he doesn't appear and then there's no presence at all. In this
Now
case,
he has appeared in this case, my lord. Thereafter, not even one of the proceedings of domestic inquiry are sent to him. He, in fact, the inquiry officer in cross-examination admits that I have not given my address. The letters have come to the management. They have been returned to the workman and they are marked, my lord, as exhibits. So, my lord, this is a case where a workman has not been told his ex parte, which is why, my lord, he thereafter addresses a letter saying, permit me to engage my co-employee, permit me to, he asks for various permissions. If he was aware he was ex parte, my lord, there was no question of sending any such letters. Nor would there be any question of sending a letter saying, for a very long time, there's been no inquiry, give me the
maybe the language used by the inquiry officer ex parte. Absent was enough. Ex parte was not necessary.
Even
Absent.
If it's taken as
Because
absent,
he was already present there.
please, my lord.
He was already served with a notice. The question
Then I'm on a much better footing if my lordship takes it as absent.
Absent is because he did not appear.
If I'm
And you
absent,
cannot give him or the principles of natural justice cannot be expanded to such an extent that he should be he must be invited to come and appear in the
no doubt, my lord. But if my lordship places on as absent instead of ex parte, then in fact I'm on a much better footing because after that, my lord, next date is not informed to me. If I'm absent on that date.
You were present and you remained absent thereafter. That is how it
No,
is.
my lord. Until and unless
Not on the first day you are not absent. You are
I've been
present.
present repeatedly for 5 days, my lord.
Then
My
you are not
stance is
present.
on that date. I'm never informed what the next date is. No inquiry is conducted. They tell me it's going to be adjourned, and I'm never informed what the next date is. If my lordship takes this stance, my lord, it will prove fatal to the workman, my lord, because the management will very easily be able to take the signature of the management official and the inquiry officer and say that the workman
ಅಂತ ಹೇಳ್ತಾ ಇದೆ
No problem.
minimum, it was required to send a notice to them that you have, that cross-examination is to be conducted, evidence has been left, documents have not been served on him, my lord. I've produced the citations, it's too well settled, but regardless, I'll produce the citations, my lord. Right to cross-examination, right to copies of documents, right to lead evidence, right to argue, my lord. None of those rights are available to him, and a finding of guilt is arrived at. And that is upheld, my lord, as I have read, on totally erroneous grounds. Saying you have had your co-employee present. I didn't have a co-employee. Saying you have not replied to show cause notice. I have replied. My lord, if the citations are required, but they are, I think they are too well settled. I will hand over the citations regardless. Serve the copy, my lord.
Just place one judgment for that proposition of.
Please, my lord.
Which is the judgment you rely now?
About the first four on the point of domestic inquiry, I'll limit myself to 1 and 4, my lord. Yes.
And
Then the rest on the question of victimization, etc. If my lordship is not convinced on the first aspect, my lord, I'll
yes,
go
you may have to go to the next aspect.
But this is a case, my lord.
Yes. On all these four judgments you rely for the victimization.
First four are for
domestic.
domestic. Now, my lord, this is a very peculiar case in terms of its fact.
Misconduct. What is the misconduct?
Misconduct is allegation that he and a co-worker, due to delay of bus, they shouted at two managerial officials, and the other workman used some abusive language and also went to assault, but was stopped from assaulting. Against me, I shouted, my lord, is the allegation against. My lord, to contextualize, section 33, my lord, is included, my lord, as a specific bar by the legislature. Stating, my lord, that during the pendency of a case, there is going to be a possibility that the management is going to target the people who are involved in that case. Thereafter, my lord, watering it down to some extent, 33 2B is brought in by way of amendment. And through amendment, we say that we are creating two categories. Where you are particularly concerned with the case or where you are protected workman, my lord, then prior permission is required to be taken. Per contra, if you are just concerned with the case, but the misconduct has got nothing to do with the case, or you are not a protected workman, then you can dismiss and simultaneously seek approval. Now, this, my submission is, my lord, this is the case where permission was required, but the management engages in certain evasion of law, my lord. What happens is that the inquiry report and the second show cause notice, my lord, is in the year 2013. The management on 13/12/2013 filed, at that time, my lord, he is a protected workman. So at that time, the management files a proposed dismissal order under section 33(3) for permission, my lord.
Yes.
Now, my lord, 2 years pass and that case continues. The main case which is pending comes to be disposed on extraneous grounds, my lord, saying there's lack of jurisdiction, etc. At that stage, the workman points out, my lord, that just because of there's a line of judgments from SN Modak onwards, think that whatever happens to the main case is irrelevant for the purpose of the permission application. This must be taken to its logical conclusion. The management withdraws the permission application, leading to the conclusion that I'm still in service. For the same misconduct, my lord,
Yes.
go on to file a 33(2)B application, dismissing me from service and filing the serial application.
Yes.
This is nothing but evasion of the law, my lord, because the dismissal was proposed in the year 2013 when he was a protected workman. As per law, my lord, if prior permission is not taken, I'm continued in service. For the 2013 inquiry, they come up in 2016 and say, now you're not protected. I've attained permission to withdraw my permission application. Now you're not protected for the same misconduct. I am now filing a approval application. So, my lord, on this ground too, my lord, this is nothing but a circumvention of the provision of law. It defeats the purpose of protection of workmen. If a management is allowed to say we are no longer protected and hence.
Any time specified for seeking application under 33 to be
It's 32 simultaneous.
simultaneous. It says during the pendency of such proceedings,
Please, Madam.
in respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to the workman concerned with such dispute, or where there are no such standing orders in accordance with the terms of the contract, whether express or implied, between him and the workman, for the misconduct not connected with the dispute, discharge or punish, whether by dismissal or otherwise, that workman, provided no such workman shall be discharged or dismissed, unless he has been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the.
And then section subclause 3, my lord, is difference. The difference is the last few lines, same with the express permission in writing. So how it works in fact, my lord, is whether if it's connected with a dispute or if you are protected workman, a proposed dismissal order is passed. You're never dismissed. A proposed dismissal is filed. Proposal for dismissal. It's filed before the tribunal where the case is pending. And if permission is granted, that proposed dismissal comes into effect. So that proposed dismissal has been filed, my lord, and I will take my lordship to the order annexure J at page 83 of 2677.
Page number?
Page number 83, my lord. Annexure J. Now, this is the order which comes to be passed on the withdrawal application, withdrawal memo filed by them in the permission application. I would take my lordship to page 85, para 3.1.
Yes.
Where the workman specifically contends, if I may read my lord, 3.1. He also submits that without prejudice to the contention of the opposite party, again it is further contended that the management cannot pick and choose their stand cleverly with malified intention in order to disobey their obligation, filing 33 CB application, since the opposite party workman was covered under the status of protected workman as on 13/12/2013. Thus, it has to be disposed in accordance for law, since there is no provision for withdrawal. This was the argument made by me, my lord. And I also read after content. He further contends that one more industrial dispute in respect of lockout to the workman was also pending. Hence, the management cannot play with the workman on technical grounds. Then, my lord, I make further 3.3 is on the next page, my lord.
Yes.
On the next page, 3.3, I also rely upon the judgment of the Honorable Apex Court.
Yes.
I believe this is Delhi High Court, but there are sufficient judgments of the Apex Court as well that the proceedings for application for approval under 33 2B would not automatically come to end by reason that the main dispute had been decided. And that, my lord, is settled proposition of law. Then, my lord, if I might take my lordship to page 88.
Yes.
4.2, my lord. Again, the same submission is made that the authorized representative of the opposite party submits vehemently that if the application is withdrawn, he can be dismissed at any time. But since permission is to be granted under 33 2B, he is getting full wages as a result of duty. Because until the proposed dismissal fructifies into a permission order, my lord, then there's no question of dismissal. But, my lord, the court goes on to hold, my lord, that the applicant is the master of the case, my lord, and grants permission to withdraw.
That order has attained finality.
That is attained final. In fact, my lord, on that proposition also we cannot challenge that proposition. They are the master of the case. The consequence of withdrawal of the permission application must lie on them, my lord, not on me. My lord, so this is the second ground on which I seriously contend that this is the case that without prior permission, no doubt, my lord, on the date of filing the the approval application, the SLA which is before this court, I was not a protected workman. But the fact of the case is when the cause of action arose, when the dismissal was proposed in the minds and in letter of by the management, was at a time when I was a proposed workman, when I was a protected workman. And therefore, my lord, the question of evading the scope of law and then seeking approval would not arise. Then, my lord, the question of victimization. Of course, my lord, I'm bound by John D'Souza's case. I have a limited scope in 33(2)B applications, and I will confine myself to the limited scope. Regardless, John D'Souza does hold that after the domestic inquiry, even when the domestic inquiry is held to be fair, even then you have the tribunal must go into the question of whether it's an unfair labor practice, whether it's by victimization, and lift the bail if so. My argument before the learned tribunal was this is a clear-cut case of victimization. I also took the argument of perversity, which is also possible, available to me. If I can take my lordship to my evidence affidavit on victimization. It starts, my lord, at page number 136. In para 2, he notes that he's the organizing secretary of the union, my lord. He's been working since
What is
1996.
the victimization according to you?
According to me, my lord, they have removed the general secretary, the president, the founder, and I am the organizing secretary. All of them have been removed within a small period. The morning of that incident, I give a complaint to the canteen committee stating that, and in fact, there's a line of complaints which I've produced on various issues. One, my lord, is I've given a letter saying that I'm not being allowed to use the toilet. Who should I ask if I'm giving the toilet? The management gives an endorsement on that letter before this court, saying we will consider and get back to you. They don't get back to us. Within the year 2012, my lord, there are lots of issues between the union and the management. In para 5 of my evidence, I laid on a list of 10 cases pending between. So there's some friction which arises in this year, my lord. Now, on the morning of the alleged incident, my lord, I gave a complaint stating to the canteen committee, naming 2 of the management witnesses, stating that there are worms in the rice which is being given to us. As the organizing secretary of the union, I give a complaint saying, please rectify this. Their statement, my lord, their allegation against me is limited to a period of 10 minutes. The allegation, while the charge sheet, my lord, there are huge discrepancies between the charge sheet and the evidence. Now, my learned senior will definitely point out that the scope of going into evidence is limited, but my lord, it is available to the extent of showing perversity. So, my lord, if I can take my lordship to the charge sheet.
This is limited to whether there was victimization or
Yes, my lord.
and considering this 33(2)B.
But
So
color
whether we can go into the extent of what was the evidence which has been laid.
The Telecast judgment of Supreme Court says that victimization, my lord, is divided into victimization in fact and victimization in law. When a punishment imposed for here, it's 5 minutes, my lord. When a punishment imposed on a worker is so grossly disproportionate, that amounts to victimization in law, is what the Supreme Court says.
Whether when the misconduct is grossly disproportionate to the
penalty.
and the punishment imposed is disproportionate to the gross misconduct according.
It's grossly disproportionate to the misconduct.
Yes.
I have also furnished that citation. I'll take my lordship to it later.
We'll hear the respondent now for some time. Yes, senior counsel. Kindly unmute yourself, sir.
Plus, the petitioner has raised a dispute under 10(4)A and it has been referred for adjudication in 2022. And that is going on in the labor court. Now, what was sought was an approval. Now, my friends, your lordship may see, to start with, there are, kindly have a look at page 23, my lord, of the award. It comes within the award. Page 23.
Yes.
Now, my lords, kindly see, my lord, para 12. At page 23.
Yes. Yes.
My lords, the opposite party has seriously contested by challenging legality and correctness of the inquiry conducted by inquiry officer, as there are several latches and also collusion with the management as per his contention. After recording the evidence of both the parties and after hearing the arguments, my learned predecessor in office has passed an order on 11/9/2018 by holding that the domestic inquiry conducted by the inquiry officer is fair and proper. Now the point left only to consider compliance of section 33 2B of the ID Act and also regarding victimization, unfair practice as alleged in the objection statement. In the next paragraph, kindly see the last three lines. Last three lines. When all these steps are taken, my lords, it stops. About 3 lines in the next paragraph at page 24. When all these steps are taken simultaneously on the same day, it is very much sufficient to hold that the applicant has complied the mandatory provision. Accordingly, issue number 2 answered in the affirmative.
Yes.
Then comes the next one, my lord, where it says additional issue number 1. After holding that the inquiry conducted against the opposite party was fair and proper, and also after giving findings, the applicant has complied with mandatory provisions as contemplated under 33 2B of the IDA. Only point left for the opposite party to prove the victimization, if any, in dismissing from service. To that effect, the opposite party has filed an affidavit to prove the victimization. According to it starts, my lord. And finally, kindly
Yes.
see, my lords, how it goes. At para 15, my lord. In
Yes.
fact, a little earlier also, your lordship may kindly have a look at page 25, about 6th line from the top at page 25. The union has been recognized by the applicant management as a sole collective bargaining agent. In this capacity, the union has raised several demands, grievances with applicant management, and entered into several binding settlements due to it should be cooperation, but it is the other way around. They were, some of them were nearby. Applicant management is involved in a number of violations of labor laws. In this regard, several cases have been filed by the union. They're all pending before this tribunal and also industrial tribunal and principal employer Bangalore. Then after that, kindly see paragraph 15. The opposite party has admitted in his cross-examination for the charter of demand dated 10/1/2012, there was an interim settlement in the year 2012. It is further admitted that as on the date of signing interim settlement, he was under suspension. For that, the benefits were not given to him. Then thereafter, your lordship may see at paragraph 16, last 4-5 lines. I'm reading from the award. In this connection,
Yes.
inquiry being conducted, an inquiry officer has recorded the evidence of the concerned witnesses and given the finding. Even during the inquiry, the opposite party has not made any efforts to lead evidence or to produce any document. On 4/1/2013, he walked away from the inquiry proceedings, except insisting that the inquiry officer to permit him to engage one K.A. Gangana union leader. The opposite party has not made any efforts to engage his co-employee for his assistance. Even during the inquiry on 15/3/2013, he started shouting at management representatives as well as the inquiry officer. All this conduct to the opposite party does not inspire the confidence of the tribunal to accept as if he has been victimized by the applicant management. Incident as per the allegations made, the charge sheet happened on so and so, but the complaint lodged by him to the police, it was on 21/2013 as per Exhibit 01.
Yes.
Then, Malaj, At paragraph 19, my lord. In order to appreciate that there was victimization, the opposite party has relied on his own documents marked as Exhibit 01 to 018. They are the complaint copy to HR department and also requisition to the inquiry officer and other letter correspondence to the management. The similar contention also taken by the opposite party before the inquiry officer regarding manhandling using vulgar language and insulting by Mr. Pascal and so and so. But there are no supporting documents or evidence. Even if there is such evidence, as alleged, opposite party could proceed independently without tagging the incident to the present case. It is the contention that one Kuppuswamy is a co-complainant with him. Now he is working in the applicant company itself, and he has expressed ignorance regarding issuance of any charge sheet against Kuppuswamy. If really the opposite party has been victimized by the management, the better person to corroborate the evidence of the opposite party is Mr. Kuppuswamy. But no efforts are being made by the first party to examine his co-complainant Kuppuswamy. In this case, in the affidavit in detail regarding victimization, he has made several allegations. At the same time, he has brought to the notice of tribunal there are other 10 cases pending against the management. What are all those cases? Nature of misconduct and the nature of punishment that is totally different, that cannot be clubbed here. So the self-sworn testimony of the opposite party is not sufficient to accept the allegation of victimization, as his co-complainant Kuppuswamy is still working in the applicant company without facing any allegations.
Yes.
So going by the evidence, the tribunal comes to the conclusion it is not possible, it does not inspire. Now, my lords, these are the only thing that was available to the petitioner to establish that there is victimization or unfair labor practice. Merely go on repeating 10 cases are filed, 10 cases are filed is not going to help. What are those 10 cases? With what issues they are connected? They stopped work for 2 days, wage deducted, 1 case filed. They came late, some action was taken, they protested, 1 more case filed. So you file 10 cases like that and come to the court and say, we have filed 10 cases, we have filed 10 cases, therefore there is victimization. No. I'll point out to your lordship what Supreme Court says about what is the degree of proof required for victimization.
Yes.
Now, my lords, coming to the inquiry, kindly see, my lords, what has happened with regard to the inquiry. Proceedings of the inquiry at page 52, your lordship may see. Right from 42 it starts, my lord, your lordship may take to page 42.
Yes.
Normally it started. It started, my lords, and that was the first day of the hearing is 5/2/18. 4/1/2013, they have all signed. That is the first hearing, where your lordship will find the signature of the workman also at the bottom, charge sheeted employee. Then kindly see the next date of hearing.
Yes.
(25/1/13), that is at page 45.
Yes.
Here also he says, CSE came to the inquiry room and submitted that he is going out of the factory as one of the relative died and therefore requested to adjourn the inquiry and post it to 1-2. Now, my lord, one submission is the CSE or the petitioner was never suspended throughout the inquiry proceedings. He was working. He was at the factory. There is no difficulty for him to know as to what is happening in the inquiry. Then on the next date of hearing, your lordship will see at page 49. Lord, the inquiry called at 12:30 p.m. Since the MR had some engagements in the morning session, he has requested overflow to take up the inquiry at 12:30. According to the MR and CSE are present. On the previous inquiry sitting 25/1/13, due to some personal urgency, CSE could not be present to the inquiry. As advised to the MR, CSE has now received the copy of the proceedings dated 25/1/13 and the list of witnesses and documents. At this stage, the CSC has requested not to permit the MR to commence his evidence today, as he would engage an outside legal advisor to assist him in the inquiry, and a written request in this regard will be submitted on the next date of hearing. Accordingly, the MR is advised to commence the examination of management on the next date of inquiry. Again, it is adjourned because he wanted an adjournment. Then, my lords, on the next date of hearing, he was absent. That is on 16/2/13, that is at page 50.
Yes.
Then again, he did not come, and therefore it was adjourned. It was taken up on 15/3/2013 at page 52.
Yes.
Now, my lord, I'll read the proceedings, my lord. In the previous sitting on 16/2/13, the inquiry got adjourned to 15/3/13. Since the EO was out of 253 out of station, he has instructed MR to intimate the CSC and find out with the CSC convenient date. Accordingly, the inquiry was scheduled to today, that is 15/3/2013, and the MR and the CSC are present. The CSC confirmed that he has received the copy of the inquiry proceeding dated 16/2/2013. At this stage, the CSC started shouting at EO as to why the MR has made a statement at para 2 of the proceeding dated 16/2/2013, quoting, "Such attitude of the CSC should not be entertained." This is in reference to a contention by the management representative that he is simply prolonging the inquiry. Then the EO advised CSC that it is the objection of MR, and if CSC has any counter objection, he can always submit before the EO. However, the CSC continued to shout in a raised voice at MR as well as EO, stating that the proceedings are not recording as per law and that he knows all legal language about the inquiry, that he is not going to participate in the inquiry, and asked EO to record whatever EO wants. There were some sort of exchange of words between EO and MR and the advice of EO. Finally, the CSC refused to participate in the inquiry and walked away from the inquiry place. Now, this is how the whole proceedings has gone. It is not as though on the very first day he was placed ex parte. That is not correct. That's not fair.
Yes.
Even in the charge sheet, the charge against him is shouting at the officers of the company on a very frivolous issue. The same thing has continued even here. He does the same thing. He does not come. In fact, he has not been suspended also at that point of time. Even thereafter, he could have addressed a letter to the inquiry officer directly or come on the next date of hearing, because inquiry was not over by then. Inquiry continued for, I think, 5 more sittings.
Yes.
He was working, he was in the shift. Anytime he could have come and said, I will participate in the inquiry. But he made it categorically clear that he will not participate in the inquiry. Now, what should the employer do? Either I must suspend the inquiry and dismiss him straight away, in which case the court will say, why did you dismiss without holding an inquiry? And if I hold an inquiry, he will not participate. I have to place him ex parte. Where am I to go?
Yes.
Now, because he has made it very clear he is not going to participate, and in spite of opportunity given, he did not come. Even thereafter, there are 5 sittings of the inquiry. He could have come. My young friend says he made a request. Where is the request? There is no request. Now, therefore, my lords, my submission is the tribunal, after going through this, has come to the conclusion that inquiry is fair and proper. I cannot be going to his house and bringing him every day by saying, please come and all that. Now, if the inquiry is fair and proper, what remains is only 2 factors: whether I complied with requirements of 33(2)(b. I read it over to your lordship. The court specifically said I have complied with 33(2)(b) provision. That is, dismissal order, approval application, 1 month wages to be paid simultaneously, which I have done, which the tribunal has accepted. That is not an objection on the other side also. Now, victimization, the court says, what have you proved for victimization, except saying, I'm one of the office bearers and 10 cases are filed against the management. What does it mean? Does it mean that I victimized him because 10 cases are filed by the union? Therefore, my lord, tribunal No, after all, what is this proceeding, my lord? This is a summary proceeding. I would like to read paragraph 15 of your lordship's order in one other case which I have produced. Though it sounds like carrying coal to the new castle, but I would still like to make a submission on that.
Yeah.
Now let's kindly see, my lord. Lord, I have produced certain judgments. Your lordship may kindly have a look at list of authorities which I filed on 3/9/2024, my lord.
Yes.
Now, my lord, kindly see, my lord, the first one. That is Caltex India Limited. Now, my lord, at para 7, your lordship may see, my lord.
Yes. Yes.
Now, my lord, para 7, this appeal raises the identical question which has been the subject matter of our decision Atherton West and so and so. The Automobile Products of India Limited versus Ram Kumar Bala, and also Lakshmi Devi Sugar Mills versus so and so have clearly laid down there that the Industrial Tribunal has no jurisdiction while entertaining an application under Section 33 of the ID Act to consider whether the punishment sought to be meted out by the employer to the workman is harsh or excessive. The measure of punishment to be so meted out is within the sole discretion of the employer, who is to judge for himself what is the punishment commensurate with the offense which has been proved against the workman. The only jurisdiction which the Industrial Tribunal has under Section 33 is to determine whether a prima facie case for the meting out of the punishment has been made out by the employer, and the employer is not actuated by any malefice or unfavorable practice or victimization. Once the Industrial Tribunal come to the conclusion in the present case that the inquiry which was conducted by the appellant was fair and the principles of natural justice has been violated in the conduct of the inquiry, and the appellant bona fide came to the conclusion dismissal only punishment which should be meted out by them to the first respondent, the Industrial Tribunal had no power to substantiate another punishment for the one which was sought to be meted out by the appellants to the first respondent, nor to impose any conditions on the appellant before the requisite permission could be granted to them. The whole approach of the tribunal, I stop at this. Position of law has been laid down very clearly that I can understand two things, my lord. Disproportionate punishment, yes. Let us assume for the sake of argument that this is a case of disproportionate punishment. But whether that can be interfered in a proceeding under 33 or a disproportionate punishment can be looked into only when a reference is made for adjudication on merits and there is availability of Section 11A of the ID Act to the tribunal. In the present case, there is absolutely no availability. The tribunal could not have entered with the punishment unless the tribunal or this honorable court comes to the conclusion that it is shockingly disproportionate to the extent that amounts to victimization.
Yes.
Then I have no case. If your lordship says, no, this is shockingly disproportionate, therefore I will say it is victimization, that's left to the court. Now, the second judgment, para 6 to 11, that is Bharat Iron Works, my lord.
Yes.
If your lordship had occasion, because some of our colleagues from the last couple of weeks, if they have referred to this, I will not, otherwise I will refer to this, my lord.
Yes, no. You can
Paragraph
proceed.
6, my lord.
Paragraph 6. Yes.
Paragraph 6. What is victimization is again a multi-headed monster to tackle with. The word victimization is not defined in the idea. An attempt to describe unfair practices by employers by a deeming definition was made under 28K in Chapter 3B of the Indian Trade Union Amendment Act 47, but we understand it has not yet been brought into force. The concept of victimization is to a large extent brought out under Section 28K of that unenforced law, and it may be worthwhile to quote the same as it throws sufficient light on the topic and will offer guidance to tribunals in adjudicating ticklish issue of this nature. Section 25K, so I'll skip that also. Paragraph 7. Ordinarily, a person is victimized if he is made a victim or a scapegoat and is subjected to persecution, prosecution, or punishment for no real fault or guilt of his own, in the manner as if it were of a sacrificed victim. It is therefore manifest that if actual fault or guilt meriting the punishment is established, such action will be rid of the taint of victimization. It is apparent that victimization may partake of various types. To cite one or two only, for example, pressurizing an employee to leave the union or union activities, treating an employee unequally or in an obviously discriminatory manner for the sole reason of his connection with union or his particular union activity, inflicting a grossly monstrous punishment which no rational person would impose upon an employee, and the like. A word of caution is necessary. Victimization is a serious charge by an employee against his employer, and therefore it must be properly and adequately pleaded, giving all particulars, union which the charge is based to enable the employer to fully meet them. The charge must not be vague or indefinite, being as it is an amalgam of facts as well as inferences and attitudes. The fact that there is a union espousing the cause of the employees in legitimate trade union activity, and an employee is a member or active office bearer thereof per se, no crucial instance collective bargaining being the order of the day in a democratic social welfare state. Legitimate trade union activity, which must shun all kinds of physical threats, coercion, or violence, must march with a spirit of tolerance, understanding, and grace in dealing on the part of the employer. Such activity can flow in healthy channel only on mutual cooperation between the employer and employee, and cannot be considered as irksome by the management in the best interest of the concern. Dialogues with representatives of union help striking a balance in adjustment and settlement of various contentions and issues. The onus of establishing a plea of victimization will be upon the person pleading it. Since the charge of victimization is a serious matter reflecting to a degree upon the subjective attitude of the employer, evidenced by acts and conduct, these have to be established by safe and sure evidence. Mere allegations, vague suggestions, and insinuations are not enough. All particulars of the charge brought out, if believed, must be weighed by the tribunal, and a conclusion should be reached on a totality of the evidence produced.
Yes.
My submission is, what was the evidence brought out before the tribunal to prove victimization? Except saying 10 cases were filed. Now kindly see, minutes. I will refer to the next judgment in ITC at page 21, para 23 of the judgment.
Yes.
Now, kindly see, my lord, in this case, the scope of 33(2)B was also explained. Kindly see, my lord, the scope and object of proceeding under Section 10 of the Act and Section 33(2)B of the Act are different. Whether the proceeding before the authorities under Section 10 or 33(2)B of the Act, if the inquiry is defective or if no inquiry is held, the entire case would be open before the authority concerned, and the employer would have to justify or satisfy the tribunal by producing evidence that the order of discharge or dismissal was proper. In proceeding under 33(2)B of the Act, the ban imposed on the employer can only be removed or maintained. No other order can be made or relief given by the authorities in this proceeding. Even if the ban is lifted, the dispute is not finally settled, and the employee can request the reference under Section 10 of the Act. The power of the authorities in proceedings under Section 10 of the Act are wide and more so after 11A of the Act was introduced and other is enforceable. The pendency of the proceedings under 33(2)(b) of the Act is no bar for the exercise of the present under Section 10 of the Act. In these circumstances, it is desirable and proper that both the proceedings under 33(2)(b) and 10 of the Act should not continue simultaneously. Necessary, the proceedings under Section 33(2)(b) of the Act should stand concluded immediately on a reference being made under Section 10 of the Act. We may point out that the legislature has already provided Section 10(6) of the Act that proceedings before the Labour Court of the Tribunal stands quashed on the central government, making a reference of the same dispute under Section 10(e) of the Act, and Section 22(a) of the Act provides that the conciliation proceedings stand concluded as the state government referring in the same dispute for adjudication under Section 10 of the Act. It is better if similar provision is made for so and so, so and so. In other words, what the court has said is, once there is already, now in my case, the petitioner has already raised a dispute, which has already come before the Labour Court. Claim statement is already filed. It is now more than 1.5 years since the dispute has been referred. So where is the need for this approval application to continue? It may be decided as settled in view of this judgment. Now kindly see, my lord, the next one. I would take your lordship to page 47 directly, my lord. Page 47. In the one of the judgments, I will not refer, my lord. That is State Bank of Patiala. It may not be directly concerned. Paras 19 and 20 at page 47.
Yes.
Highly similar. 19 and 20. Learned counsel appearing for the respondent, however, contended that even though all courts below in regard to the factum of misconduct have held against the workman respondent, still rightly came to the conclusion that the punishment of dismissal was too harsh a punishment and was totally disproportionate to the misconduct proved. In support of this contention, the learned counsel pointed out from the award of the Labour Court that it had taken into consideration that the respondent workman had worked with the appellant company for a large number of years and held that knowing the consequences of dismissal, he would have by now learned a lesson that not to misbehave in future. Hence, he must be given an opportunity to redeem himself. He submitted the Labour Court with a set view in mind had reduced the punishment. He also, I'll leave that, my lord, it is more on 11A, my lord.
Para 20.
Para 20, my lord.
Section 11 is available only on
That
the
also appears to be under 11A, my lord.
11 also.
Not necessary, my lord. Your lordship may kindly take to page 54, para 8.
Yes.
Page 54, para 8, 18.
Yes.
18.
Approval.
The judicial tribunal, while considering an application for grant of approval, has succinctly been stated by this court in Martin, Berna and Banerjee, so and so. While exercising jurisdiction under Section 33(2)(b) of the Act, the industrial tribunal is required to see as to whether a prima facie case has been made out as regards the validity or otherwise of the domestic inquiry held against the delinquent. Keeping in view the fact that the permission or approval is granted, the order of discharge or dismissal, which may be passed against the delinquent employee, would be liable to be challenged in an appropriate proceeding before the industrial tribunal in terms of the provisions of the ID Act. In Martin Burn's case, this court stated, a prima facie case does not mean a case proved to the hilt, but a case which can be said to be established if the evidence which is led in support of the same were believed. While determining whether a prima facie case had been made up, the relevant consideration is whether on the evidence led it was possible to arrive at the conclusion, the question, and not whether that was the only conclusion which could be arrived at on that evidence. It may be that the tribunal considering this question may itself have arrived at a different conclusion. It has, however, not to substitute its own judgment for the judgment in question. It has only got to consider whether the view taken is a possible view on the evidence on the record. See, so it's so it.
Yes.
Now, but there's another judgment which I have produced. Your Lordship may kindly have a look at that judgment.
You are relying upon that Chaturvedi's case.
Let's
Chaturvedi's case you are relying
Yeah,
upon.
Chaturvedi's case is also there. And I also wanted to refer to Lordship Justice Santosh Hegde's judgment. But I have produced, I was looking where I have produced. Abusing is serious misconduct. Kindly see in Chaturvedi's case also, my lord, which I have produced on 9-9, my lord. I produced on 9-9. That is at para 12, 13 and page 11.
It is regarding the scope of judicial review.
Yes, my lord. Scope of judicial review, where my only point that I wanted to drive home was no, my lord, the only thing was what the apex court says is you only go into the manner in which action is taken, not so much on substantive portion. That
Yes.
is why it says 12 only, if I may read 12 at page 11. Mahindra versus. There, next that would begin. That's why it would begin.
Yes.
Not 13, my lord. Here it says judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Part of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of the court. When an inquiry is conducted on charges of misconduct by a public servant, court or tribunal is concerned to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with, whether the findings or conclusions are based on some evidence. The authority entrusted with the power to hold inquiry as jurisdiction, power and authority to reach a finding of fact or conclusion. But that finding must be based on some evidence. Now, I would point out to your lordship, 4 witnesses have been examined in this case. All the 4 were concerned with the misconduct that was committed by the petitioner. So, obviously, there is some evidence. Now, in fact, para 13 is even more clearer. The disciplinary authority is the sole judge of facts. Where appeal is presented, the appellate authority has coextensive power to reappreciate the evidence or the nature of punishment. For example, in a disciplinary inquiry, the strict proof of legal evidence and findings on their evidence are not relevant. Adequacy of evidence or reliability of evidence cannot be permitted to be canvassed before the court tribunal. That's all, Miller. Same thing.
Yes.
So what I'm saying is this is the only manner in which it is done. Now, I left out something in while reading in the one which I produced on 3-9 at page 47, my lords, I said in the which I produced on 3-9, your lordship may take and take to page 47, my lord.
Yes.
Para 20, my lord. In fact, I wanted to read para 20, which I missed. At page 47, my lord.
Yes.
It is no doubt true that after introduction of section 11A in the ID Act, certain amount of discretion is vested with the labor court, industrial tribunal, interfering with the quantum of punishment awarded by the management, where the concerned workman is found guilty of misconduct. The said area of discretion has been very well defined by the various judgments of this court, referred to here in above, and it is certainly not unlimited, as it has been observed by the division bench of the High Court. The discretion which can be exercised under section 11A is available only on the existence of certain factors, like punishment being disproportionate to the gravity of misconduct, so as to disturb the conscience of the court, or the existence of any mitigating circumstances which require the reduction of the sentence, or the past conduct of the workman, which may persuade the labor court to reduce the punishment. In the absence of any such factor existing, the labor court cannot, by way of sympathy alone, exercise the power under 11A of the Act and reduce the punishment. As noticed herein above, at least in two of the cases cited before us, that is Orissa Cement Limited and New Shorak Mills, this court held punishment of dismissal for using of abusive language cannot be held to be disproportionate.
Yes.
In this case, all the forum below have held that target language used by the workman was filthy. We too are of the opinion that the language used by the workman is such that it cannot be tolerated by any civilized society. Use of such abusive language against a superior officer, that too not once but twice, in the presence of his subordinate, cannot be termed to be an indiscipline, calling for lesser punishment in the absence of any extenuating factor referred to herein above. That's all, what I wanted to submit was that one should not say only when somebody is assaulted, it is a misconduct, worth the dismissal. Abusing is all right, is okay, it is accepted. Supreme Court says no. Abuse is equally bad. It also warrants dismissal from service. Now, kindly see, my lord, paragraph. On 21/6/23, my lords, they would copy that. Yes, sir. On 21/6/23, at page 25, in paragraphs 15 and 17, it's
Yes.
only refreshing your lordship because your lordship has authored the judgment.
Yes.
Now kindly see, my lords, what is it? 15 and 16.
Yes. Considering John D'Souza's case, yes.
Since your lordship has authored this, my lord, I will only refer to this, my lord, paragraph 15 and 16.
Yes, yes.
Then, my lords, my submission is for a moment.
Yes.
Lords, kindly have a look at this for a moment at the charge sheet also, my lord, at page 38.
Yes. Yes.
No, the charge is you are so impatient, and when a band is declared, vehicles were brought to send back the employees. They were not asked to work. The vehicles come 5 to 10 minutes late because of the band. You create such a situation there, virtually threatening or abusing the officers. Now, kindly see, my lord, it says very clearly, when you saw I am reading para 3, my lord, at page 38.
Yes.
When you, lordship, get that, my lord?
Yes, yes.
When you saw the HR official near the canteen, as mentioned above, you questioned HR officials why the transport vehicles have not yet arrived at the gate. You were told by them that because of the disturbance of the vehicle are delayed by 5 minutes. Immediately you raised your voice and shouted at HR official, stating that it is the responsibility of the company to provide the transport inside. Due to delay of the vehicles, you demanded overtime for the workmen. In the meantime, Ms. Chaitra, officer HR, contact the transport vendor and the gate and inform you that the vehicles have just arrived at the gate. Instead of boarding the vehicle at the gate, you along with Raghu M.A. shouted at HR officials in singular language and threatened them. You further shouted at high pitch that HR officials are behaving like dictators and they will be taught a lesson. You along with Raghu M.S. rushed towards Mr. Nagesh, HR officer, when he tried to pacify you. You raised your voice at Mr. Nagesh. You shouted at him with loud noise, stating that Mr. Nagesh should not interfere and should keep quiet. You further shouted at him, stating that Mr. Nagesh has no authority to interfere in the matter. Because of your shouting at Mr. Nagesh, Mr. Raghu got excited and rushed towards Mr. Nagesh to assault him. The timely intervention of other HR officials stopped Raghu approaching Mr. Nagesh. Now, why should a company tolerate this behavior?
Yes.
This is not normal behavior. Therefore, my submission is prima facie, the charges are good enough and dismissal has taken place. That's what the Supreme Court says. Look only into it. Unless your Lordship's conscience is pricked because of my dismissal for this act of misconduct. As I already submitted, where 11A is available, disproportionateness of the punishment is different from a punishment given which shocked the conscience of the court.
Yes.
Therefore, I would still say he has already raised a dispute under 10.4A and there 11A will be available. He may persuade the presiding officer to take and impose or reduce the punishment. Whereas in an approval application, courts have said either you grant approval, you don't grant approval.
Yes.
If approval is not granted, I end up in paying 30-40 lakhs of rupees for all the behavior that he has had. What morals will my employees have when one of their workmen whom they have seen behaving in such a manner gets about 30-40 lakhs for nothing? Therefore, my submission is, my lord, this is only a summary procedure, summary proceeding. This is not final. The workman still has remedy. Therefore, my humble submission, approval maybe whatever is granted may not be interfered with, and the petition be dismissed. Not valid. Oblige, my lord.
All points by way of reply, my lord. My lord, 2 points on the domestic inquiry, my lord. So I understand the position of this court, my lord, but 2 points to convince my lords. I can turn my lordship to what the initial conduct of the management was when the CSE was absent. Whenever the CSE was absent initially, my lord, for example, I will take my lordship to page 53 or 51. A copy of the proceedings was directed to be given to CSE. If, my lord, he is absent now, the minimum requirement upon the management is to serve him a copy of the proceedings by way of hand or by way of post. If that had been done, my lord, I could have no further complaint if I choose not to agitate the issue, not to cross-examine, not to enter appearance.
Yes.
But my lord, thereafter, if my lordship can see, for example, my lordship can see 58, 60, etc., all the subsequent proceedings, they only furnish one copy to the MR. No copy is ever given for the workman, my lord. My lord, when no notice has been given to me of the next date of the hearing, then, my lord, it's a gross violation of natural justice, my lord. Secondly, my lord, if my lordship can take page 56, the second paragraph, I have given a letter at that stage, my lord. At this stage, the MR produces CSE letter dated 3/4/2013 addressed to the EO. The said letter is taken on record as Annexure 6 after furnishing a copy to the MR. In the said letter, the CSE is requested to permit him to engage K.A. Gangana and to record the proceedings in Kannada. My lord, if he was placed ex parte, no such letter could have been furnished by him. Moreover, an order comes to be passed on the said letter, rejecting the said letter. That order copy is also not sent to him. Then thirdly, my lord, I started reading it on the last date and then due to paucity, I didn't continue, my lord. But my lord, the reply to second show cause notice, where he very validly explains the whole course of events and how he was not aware the inquiry was proceeding behind his back. It starts at page 80, my lord, when I was reading, my lord, before my lordship. And it continues at page 81. If I may read just from the last word of page 80 onwards.
This portion.
I was reading the portion, my lord, but the points he raises, my lord, is that he was not aware that the inquiry was conducted. He gives a letter saying why is it taking so long, my lord, and that comes back as, in fact, he approaches for inquiry officer address. Then that those letters come back as not served, my lord, as rejected by the management. And then, my lord, in the cross-examination of the inquiry officer, which is available, my lord,
Yes.
at page number 128 of the same petition.
Yes.
8 lines from the top. It is true to suggest I have not mentioned my address in the records of proceeding. Witness volunteers that have mentioned my name with care of company address. I have not issued any separate letter to the workman through communication. The witness volunteers I have sent subsequent proceedings. It is true that the 2 covers sent by the opposite party addressing to the inquiry officer have been returned. The witness volunteers by this date inquiry was closed, but no notice was ever issued to him. For him to know that inquiry is proceeding, inquiry is closed, cross-examination is to be conducted, documents. Well, this is the case where all the core components of compliance of national justice have not been. Now I understand, my lord, there might be cases without conceding, my lord, that supposing I shout and I walk out of an inquiry before the evidence has commenced, and if the inquiry is to go forth without me, my lord, can the sole act of me walking out of an inquiry, assuming, my lord, that I walk out of an inquiry, can that be sufficient to deny me the opportunity of cross-examining the witnesses, of the documents, of argument, of my evidence, my lord, my co-workers' evidence, my evidence on victimization? All the core elements of national justice have been denied to me, and it's justified, my lord, on grounds that I've walked out. Now, where, my lord, there are 2 such evenly balanced positions. Management is saying one thing, I am saying something else, my lord. It could easily have been cleared with a simple RPAD notice to him. Next date of your hearing is also present or we are continuing without you. No such notice is given to him. Now I'll end on that point, my lord. The second aspect which I wish to respond to, my lord, is, my lord, the question of disproportionality. My lord, my submission, my lord, no doubt the position of law is clear, and we are ad idem on that disproportionality is generally invoked under 11A. It will be invoked under 33TB, where the disproportionality is such that it reveals victimization. This is a case, my lord, where he's appointed in the year 1996. From 1996 till 2012, without a hint of misconduct, he's worked as a technician in the establishment. Admittedly, the position of the management is this is raised voices in a span of 5 minutes, my lord. Is 5 minutes adequate to dismiss him? The judgment relied on by my learned senior was that abusive language can no doubt be a ground for termination, my lord. But here, my lord, there's no abusive language alleged against me. The abusive language is alleged against my co-employee. Then, my lord, learned friend has referred to the charge sheet, my lord. There, certain serious allegations are made against me, no doubt. And certain components I wish to highlight before, my lord. Firstly, stating that it's the responsibility of the company to provide transport. It's at page 38, my lord.
That has been read already.
Yes, my lord, but I wish to point out certain points, my
What
lord.
is that point you want to say? What is that point you want to?
My lord, singular language taught a lesson, being treated as dictators, demanding overtime, should not interfere. All of these aspects, my lord, if my lordship turns to page 70, which is the evidence before the inquiry officer. In the evidence, they never say any of this. They say that he shouted and the co-employee rushed to assault. The co-employee made abusive language.
Yes.
None of these components are even made out in the evidence, my lord. My lordship can take page number 70. 69 last 2 lines onwards to 70, my lord. MW1 further stated he was present on 29/11/2012 and at about 2:05 the HR team, he and the HR team were completing the lunch. At that time, a group of technicians led by Mr. Raghu and the CSC came and surrounded him and questioned as to why the transport vehicles have not arrived. Further, he has told the CSC and Mr. Raghu he will check with Mr. Indra and informed. The CSC immediately started shouting at him in dazed voice. Then he advised the CSC to remain calm, and meantime his colleague Mr. Nagesh advised CSC not to raise his voice and keep calm. Further, the CSC suddenly started at Nagesh, and all of a sudden, Raghu, on the instigation of CSC, came and showed his index finger, threatening and abusing in abusive language. My lord, all the competence that I shouted in singular, I termed them as dictator. All of the allegations against me are not even made out in the evidence. I have not been granted an opportunity to even cross-examine all these points. Then, my lord, I would like to highlight the aspect which I initially argued on 33.3, my lord, that he was a protected workman. That aspect has not been responded to by my learned senior. And finally, my lord,
Discipline is very important.
my lord, discipline is important, my lord, but where irrefutably the general secretary, the president, the founding member, the organizing secretary of a union are dismissed within a period of 6 months.
Is it related? Is it charge sheet in relation to something in conduct with the union? Is
Yes,
it
my
in
lord. In
conduct
fact, that
with
was
the?
what it is, my lord. And in fact, that was what my learned senior was questioning. What are the materials to show victimization? I've produced those materials before this honorable court. As
So the
annexed
charge sheet does
QC.
not indicate anything that there was some union dispute or anything.
The charge sheet will never indicate
No,
that.
but then, see, there would be some inclination as to why he shouted. But the shouting by the workman, by the CSC was in respect of certain circumstances which was transpired, not
according to me, but I was not given an opportunity to cross-examine them.
that is there for you.
The sole.
It is available to you in the proceedings which has been initiated already.
My lord, I would request my lordship to consider lastly the annexure came, my lord, at page 185. I've detailed, my lord, while dictating my lordship, I consider, I've detailed the various contentions taken by us. Thank you, bless.
My lord, one submission may I make, my lords. If,
Yes, senior counsel.
my lords, if your lordship were to hold inquiry is not proper, your lordship may have to remind the matter, my lord, because I have a
Yes.
right to read evidence on merits on the matter and then get the approval.
Yes.
That is the only thing, my lord.
Yes. That would have to be done. Yes.
Tomorrow for dictation.
Oblige, my lords.
Day after tomorrow for dictation. This matter is regarding the interest portion.
I will be able to control my submission. Taking into the 4 judgments on exactly identical cases. For two decades back, I mean, 3 decades back.
So what was this? You were supposed to get instructions in this? This was this?
Because we got
Well, the other day, AAG had appeared that matter, right? Interest portion.
identical cases. The defaulted amount has been paid. Minus the.
This is forfeiture, right? This is the forfeiture.
Forfeiture is not permissible, it will. Both legal names and non-legal are identical. Forfeiture is only for default in permission the bank guarantee. Here he continued.
But you have not challenged the order of forfeiture before this court. Have you challenged the order of? No, has he challenged? Have you challenged? No, no, you have not challenged the order of forfeiture. What? Now, what has been challenged now before this court? You are seeking for a direction. You are seeking for a direction to adjust that amount.
This money deposit amount, for the later development is that relationship. Government has extended.
Same.
For a samadhana.
Yes. Till 30th of 31st.
That is waiving of the interest.
Waiving of the interest.
That this court is.
Amount has been deducted. Minus the forfeited amount. Forfeited amount is adjusted.
The forfeited amount cannot be adjusted. No, that is not, you are not challenging the order of forfeiture. After tomorrow at 2:30. 2:30. We will manage in that way, please. 2:30. So all matters of workmen, labor, so then it is little, yes, it takes some time. Yes. And 2:30 matter, 2:30 matter. Yes.
Yes, Miller.
Just a moment, madam. Just a moment. Which is your matter, madam?
Miller, the 230 matters, there are 7 matters, Miller. 4 filed by the workmen and
We'll
3
take it
filed by the
tomorrow.
management.
Take it tomorrow, definitely at 2:30 only.
Miller, nah, tomorrow, early part of the day, I'll be. Tomorrow, my evidence. That's why last time when I moved,
Correct,
I said
correct.
one day only. Tuesday, only on Tuesdays, Miller, I'm not. My personal matters are posted for evidence
Then
on
tomorrow
Tuesdays.
in the dailies, the cost list is already issued. It seems
Yes,
now it will
madam.
come in the second list.
Wednesday, Miller?
Wednesday. Wednesday at 2:30.
Yes, Miller. Yes, Miller.
Wednesday at 2:30. Senior
Yes,
counsel, Mr.
Yes,
Kanstoor,
only one thing.
sorry
I-
to make
I have
the
come-
senior counsels wait
Yes.
because we were into matters which was going on. Yes. So on Wednesday at 2:30.
Yes, Miller.
2:30.
Yes, grateful to you.
Stay extend Madi. Which is that? In series up to 60.3, 60.4, 60.5. Interim order granted earlier is extended to the next date of Wednesday. 2:30. Yes. And this 2:30 matter, Mr. GK Bhatt. Tomorrow? Tomorrow in the second list, but after tomorrow at 2:30 again. 2:30 we have that batch matters. No, that will take some time. When do you want? Which? Next Wednesday will be. Anyway. Yes.
30 adjournments of this term. I am now.
Anyway, we have treated this as part heard. We will dispose of this matter, Mr. J.K. Bhatt. Correct. We understand. We do respect you, Mr. J.K. Bhatt. Yes.
Person, I have that discipline. And never acted before my not invitation.
Correct. We never said so that you were asked.
And in this case, poor person does not have to stand with.
We will see on the merit. Is it not, Mr. Bhatt? We will take it on merits. We will take it at request of the respondent counsel. Learned Senior Counsel G.K. Bhatt is present before the court. Learned Counsel appearing for the respondent 6 times at request. This matter on Wednesday at 2:30. at 2:30. Yes, Mr. Nayak, you are having your hand on your
20
head.
and 24.
You are having your
May,
hand on
may I
your
make one request, madam? May I make one request? ಇದ್ರೊಳಗೆ ಇದೆರಡು ಮ್ಯಾಟ್ರ್ 20 ಮತ್ತು 24ನ ನಾವು 23 ಅಥವಾ 24ಕ್ಕೆ 2:30 ಅಂತ ಏನಾದ್ರು ಹಾಕೋಬೋದಾ ನೋಡಿ. 17 ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ವಿ ಆಗಲೇ. 23rd and 24th date convenient.
Yes, we will dispose that matter.
24 also my lord same day.
Before the
24
roster
also
gets
same
complete,
day,
we
my
will
lord.
dispose that matter, Mr. Nayak, before the roster is completed. Yes.
Yes, yes. ಖಂಡಿತ 24 ಅವತ್ತು ಹಾಕೊಂಬಿಡಿ ದಯವಿಟ್ಟು.
24th or 23rd?
23rd serial number 20 and 24.
20 and 24.
The 24 2009 matter.
Yes, yes, yes.
23rd at 2:30.
20 na?
Much of it.
Oh, 20 and
20. ಅದೇ ನಮ್ದು ಕಸ್ತೂರಿ ಅವರು.
23rd at 2.
Final argument serial number 20 and 24.
Correct.
Yes.
And on 24th or 23rd you want? ಯಾವತ್ತು ಬೇಕು?
23rd ಕೊಡಿ ಪರವಾಗಿಲ್ಲ. 23rd full ಆಗಿದೆ, 24th ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ.
Serial number 20 and 24 at 2:30 on 23rd. Yes. Yes. Yes, Mr. Suresh. What is the KLRA matter 2001? No, it was reached earlier. Now it is not reached. And Revenue Act, are they? What will happen after so many years? But how will you explore a possibility of settlement in KLRA matters? So, rival tenant, huh? He's a landlord. Owner. Site, or the area. See, now this government will come in your way for settlement. Government will come in your way for settlement. You have to settle the matter. Then you have to think how the government would react for this. Now, what is the total extent of land? 5 acres, 12. And what was granted to them? What was filed by them? What was filed by them? Form number 7. Yes.
Houses of the agricultural laborers. Whenever agricultural labor, it can be granted if it's a
They have admitted that she is the agriculture. And you're challenging that order now.
He is not agriculture labor under me. He is agriculture labor
what section 38 says, if in any village an agricultural labor is ordinarily residing in a dwelling house on land not belonging to him, it has to be not belonging to him, then notwithstanding anything contained in other law, but subject to subsection so and so, such dwelling house along with the site thereof and the land immediately apperent thereto and necessary for its enjoyment shall on the date of publication of 1978 Reforms Act in the Official Gazette vest absolutely in the state government free from all encumbrances, and all the agricultural laborers shall be entitled to be registered as a owner. So she was registered as an owner. After the Land Reforms Act came into force, this was vested with the government, and then she has become as a registered owner thereof. She was residing as on that date.
He has constructed a hut there.
Then
And other proceedings are also.
And this
being
under
taken
section
place.
38, she files an application seeking for grant of this land. And this site has been granted to her. And this was been admitted in your cross-examination that she is residing in the site. So that's all.
Even the other proceedings have taken place. OS has been filed.
What
We
happened to
said
that
we
one?
take it in our favor in respect of the very same site.
You may have filed a suit amongst yourself. She is not a party to that.
No, he was a party.
What was that?
He was a party.
What was the suit
Depend
for?
number 1 and 2 are the parties.
What was the suit
Respond
for?
number 1 and 2.
What was the suit for?
For declaration and mandatory injunction to remove the hut.
To remove the hut.
Yes.
And that was granted.
Typically, they have constructed it there. There on the 5 Kata land.
That is the provision which says that it should not be belonging to them, but they should be residing. That's all it says. That's how the Land Reforms
Half
Act.
portion of the hut has been constructed in the government road and other half portion is constructed in the Kata land.
Yes.
For that.
So what is that you have challenged now, the grant in your favor?
Have been filed.
And what? VT9 order. When was it challenged? 2001. How many years delay? How many years?
Here once the file has been filed before December 4. Earlier, we have challenged the order of the land tribunal.
Today, 2001.
Alleging that order, we have filed a appeal.
That is
When
what
it is
is.
being filed.
See, we are not saying when you filed originally,
Tribunal
but
was abolished. We filed a CP before December.
understandable.
So that was converted into writ petition.
That is how the procedure was then.
Yes.
Now,
And other litigations are there. We filed a OS, so that is in our favor. Decree and judgment has been passed in our favor. Thereafter, RA has been filed by them, challenged before them, before the Madhugari court, which came to be dismissed, against which RSA has been filed before this court, which also came to be dismissed. In respect of the very same site.
how about the suit at least maintainable then? How was the suit maintainable in respect of this?
No. Before passing of the tribunal order in the year 1978, we filed the suit.
And when was the order of the tribunal passed?
1989.
Civil court is different and now this
They have
tribunal order is different.
they have suppressed all the
See,
cases
this is
which
a
have
grant.
been filed before
This
this
is a
order.
grant under the Karnataka Land Reforms Act. And yours was when the Land Reforms Act, there was no grant in their favor. In that circumstances, the civil court had passed the order.
Yes.
Now the civil court had no jurisdiction to pass an order when the grant tribunal grants occupancy rights in favor of the.
No. They have suppressed all the cases which has been filed before this court, and parallelly they have instituted a case before the application before the tribunal.
Dismissed to counsel.
Therefore, the section 38 itself does not attract.
As on the date when this Land Reforms Act came into force, she was in occupancy of those that site, that house, that shed.
Meanwhile, that was removed, my lord. Once the civil case has been filed for mandatory injunction, court has directed them to remove the hut. So that has been removed. There was no existence of any hut there.
In what way you can do something for the respondents?
So that's what he is trying. So if
Otherwise-
it is being sent to mediation center, we'll see that whether a 30-40 site can be given or in terms.
Settlement before this court would not be possible by finding any compromise. Either you have to settle and then we have to say an order to be passed in their favor. Not joint member, you have to settle out of court, not to the. Yes. Both the consuls submit that they would explore the possibility of settlement. And a request is made to refer the matter to the mediation, Karnataka Mediation Center, Bangalore. A joint request. Parties are referred to the Karnataka Mediation Center, Bangalore, to be present at on date 23. When do you want to go? 21st. 21st, 28. 28. 28 at 2:30. Or anyway, it is Saturday, you can appear in the morning. Saturday at 10:30. So 2:30. Yes, next matter. Subramanya Bhatt. 2002. Regarding
Paid into the retired employees of Resilience.
retired employees, huh?
Years ago. And the government had released 47 crores. Out of it, 40 crores. Then as far as 7 crores is concerned, that amount has not been released. So in that context.
How many workers? How many workers?
Let's say 1,000 workers.
You are in this petition.
Now, in that context, your lordship had directed the government to file an affidavit as to what has happened to that 7 crores. Now, of course, they have filed an affidavit, but they have produced some documents which does not represent these 7 crores. That on the last question, I pointed out that then it appears the validity.
What happened to that 7 crores? And we will see what will happen then when they say something about it. Please. At request of SCGP, list this matter as a final chance on 18. Same, no?
Sugar factory. I am ready.
So we'll take it on 18th. 18th, better 17th. This is on 17th, 23rd on 7th, 23 on 7th. Please. Mr. Safet, what happened?
In fact, your lordship, this man, you had led, I was learning the position very clear. I argued back.
Wait, before this court.
Before this motion court in the year 2023. And after the end of the argument, my mother friend proposed the settlement. And then after they didn't whisper anything. And after 6-7 months, again they come back and say this is settlement. They dragged one long year in the negotiation. And finally they come and
there's no possibility of settlement.
There's no possibility. This could be last.
So we will hear this matter.
My submission, your lordship. Right to 2014, by the petitioner, while in the words of Justice Kemar, but then Chief Justice, this matter, I'll just read it for 1 minute, that's all. An organization like Bata India Limited is not expected to re-educate issues which have obtained finality before the Supreme Court. So about an hour's court time has been wasted by this by the time is already to be filed. The appellant must bear the responsibility for wasting precious court time. The petition for special appeal having been dismissed by the Supreme Court.
What was this matter regarding? Termination, order of termination.
Or immediate termination. And petitioner is assailing the order of the industry tribunal in this petition. Apart from this petition, there were 9 matters. So the petition of water company had issued
what happened to those writ petitions?
9 petitions. They had the order of the tribunal already been disposed in the year 2008.
Where is that order?
That is here. So against that, the petitioner had come to the Honorable Court in the 9-8.
What happened?
And that petition seemed to be dismissed with learned single chair. Against the order of the learned single chair.
Writ appeal. What happened?
In one such writ appeal.
Did they go before the apex court?
That is the SLP 8187 of 2009. The SLP also got dismissed by the Honorable Supreme Court.
Yes,
In the light of the decision rendered by the Honorable Supreme Court, the 8 remaining writ appeals before this division bench also got dismissed. Pursuant to the order of the dismissal of Traditional company has reinstated the co-workers of this respondent in the year 2011 itself, paying company back wages and conservation benefits.
yes.
Now, while this respondent stays before the tribunal got delayed, and because of that, his orders before the tribunal seem to be passed away while all his co-workers were already reinstated in the company and they are working. So, my humble when the ratio definitely of the Honorable Supreme Court and the rate that applies slightly in this case, it should not have taken more than 10 minutes for the matter to be completed, despite that traditional company has embarked on a vexatious right from 2004. The atrocities they have not even.
When do you want to hear this matter on marriage? When do you want?
Oh, you are not sure. He's been coming every time from Monday.
Why he should come? Is he going to lead any evidence? No, no. You are there to argue. So ask him to sit there. Don't ask him to be present before the court. Yes, ask him to sit there. No, ask him to sit there. Nade. Second list. Tomorrow. Tomorrow at 2:30. Yes. Yes, Mr. Shekhar. ಏನಿದು ಅಬ್ಸೆಂಟಿಸಮ್ increment ಎಷ್ಟು ಒಂದು I think this was before the Lok Adalat. This matter was before the Lok Adalat. Settle ಆಗಿಲ್ಲ ಎಷ್ಟು ಒಂದು increment how many? What was the misconduct? Absenteeism. Madam, absenteeism. Sanjeev. ನೀವು ನೋಡ್ಕೊಳ್ಳಿ Sanjeev is not here. Just look into that. If at all they can be reduced. Yes, madam, where are you? See, we are calling your matter. You don't want to appear. Then. You just look into that. Just absenteeism. Lady alva. ಹೌದು ಮಾಡಿ ಅಂತ ಆಗ್ಲಿಲ್ವಾ ಅದು yes this we will take up tomorrow ಎಷ್ಟು absenteeism ಎಷ್ಟು ದಿವಸ sometimes we may have to 2 years. Yes, ನಾಳೆ ತಗೊಳ್ಳೋಣ ನಾಳೆ Monday. ಒಂದು think of it. Ask them to think. Nodi, is it possible? Just look into it. Monday. Tuesday. Just look into it. Next matter, Mr. Naik, Renuka madam is here. No, Tuesday, na? Tuesday.
ಅದು gratuity matter, section 2, capital A.
Monday, Tuesday. Yes, Mr. Prabhakar.
I appear for respondent.
Yavudralli? Oh, this matter. You are a workman.
There are 10 have dead, my lord. Another 14 they are more than 70 years old. Some preference may kindly be given to this case.
Yes. When do you want? Someday at 2:30 you take, but 22 matter, but only thing,
Would be
when do you want?
at the earliest, my lord.
Kudi. 17 ಗೆ ಕೊಡಿ, 17
Yes, yes, my lord.
on 17th.
Yes, my lord.
Nagbhushan, yes, you are appearing for the first time after 1 month. After 2 months,
I appear for respondent.
Yes, when do you want? 24 ತಗೊಳ್ಳಿ.
Yes, ma'am.
Mukundappa. Take it up on 17. Dismissal, case of dismissal. 36, madam. 2 days for labor matter is not sufficient. How much matter? ಇನ್ನೊಂದಿನನಾ? Although we have got other matters also, right? The roster is, we have got second appeals, we have got,
ಇಲ್ಲ ಇಲ್ಲ ಇದು ಸಾಕಾಗುತ್ತೆ 2 ದಿನ ಆದ್ರೂ ಈ 2 ದಿನದಲ್ಲಿ ಬೇರೆ ಸೇರ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಾವು
many other matters come up, right? Further hearing ಅಂತ ಬಂದ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ ಅದಕ್ಕೆ ಅದು ಬಂದ್ಬಿಡುತ್ತೆ, ಅದು ಪ್ರಾಬ್ಲಮ್ ನಮಗೆ. ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲ, ದಟ್ಸ್ ಅವರ್ ಗ್ರೀವೆನ್ಸ್ ಅಂತೆ. ಅದೇನಾದ್ರು ಸ್ವಲ್ಪ ಅವಾಯ್ಡ್ at least to some extent we can get labor matters disposed of on Monday and Tuesday.
RSA some matters come, but this
ಇಲ್ಲ
excise
ಒಂದು admission no problem.
we can't say no to them.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು.
39 ಯಾವಾಗ ಬೇಕು?
ಅದು ಸ್ವಲ್ಪ ಏನಾದ್ರು ಆದ್ರೆ ಸರಿ ಹೋಗ್ಬೋದು.
17-9.
39 ಅಂದ್ರೆ KPTCL. 17 ಬೇಡ, 17 ನಮಗೂ ಐ ಥಿಂಕ್ ಒಂದು ಕೇಸ್ ಇದೆ ಧಾರವಾಡದಲ್ಲಿ, ಸೇಮ್ ಇಶ್ಯೂ.
ಯಾವ್ದು ಬೇಡ ಅಂದ್ರ ನೀವು? ಯಾವ್ದು
It is fully covered now. 39 is fully covered.
Sumanand, appearing for. When do you want? We'll take it on 24th. 24th.
ಅಷ್ಟೋ ಡಿವಿಷನ್ ಬಂದು ಧಾರವಾಡದ ಇನ್ನೊಂದು ಬಂದ್ಬಿಡುತ್ತೆ ಜಡ್ಮೆಂಟ್.
24th. 37. ಆಯ್ತು. This is matter after 2 weeks ಅಂತ ಹಾಕೊಳ್ಳಿ at request of the petitioner. 38 Narasimhan. 24th. We'll make an endeavor to complete this at least till 16. Possibility of 16. Yes. Shekhar, when do you want? Then we got those papers, it was available anta iತ್ತು. We got it from the registry alva? Illa? Adu beda. Letter they have written, some letter they have. We'll take it up on Evaga 17. Yes, Vivek Varla. Where are the employers before this court? Employees. Learned counsel for the petitioner submits that there is a possibility of settlement and request for a short accommodation. This matter after 2 weeks. Yes, Shekhar? Evaga? 24th. 18 and all after 24th. Mukundappa? All after 2 weeks. Basvaraju? Stay, 17. ಯಾವಾಗ ಹೇಳಿ?
In
Date.
45, you can connected petition, I was directed to take notice, my lord, but copy is not served on me. Writ
Petition
petition.
copy ಕೊಡಿ ಅಲ್ಲ ಅವ್ರಿಗೆ. Mr. Somshekhar, ask your
Yes.
colleague to take the copy. He is making
Yes.
his efforts. You are
Yes,
not
ma'am.
busy.
Yes,
ಫೋನ್
ma'am.
ಮಾಡಿ ಹೇಳಿ ಅವರಿಗೆ ಕೊಡಿ ಅಂತ. Yes. When do you want? 24th. Yes, Renuka, madam. 23rd. Shekhar. When do you want? 21, 49. Yes. Idralina. Dismissal, madam, just look into this. Just look into that. Huh? So this is a genuine case. This is so just. So we'll take it up on day after tomorrow. Day after tomorrow. Monday. Tuesday. Just see into that. Dismissal, order of dismissal for absence, Alva. She's a lady. She's a lady, right? She's a lady. What circumstances prevailed upon her not to attend the work? We don't know. Correct. No. No, dear. Aito. Monday. Tuesday. Huh? Yes. 49 aito. 50, madam. 23/9. Shekhar 23/9. Amel 52, 23/9. 53 court hall moved ಯಾರು ಮಾಡಿದ್ದಾನೆ? ಏನಂತ ಅವ್ರು ಏನ್ ಹೋಗೇ ಬಿಟ್ರು ಅವರು ರಿಸಿನಲ್ಲೇ. Yes. Again, we asked her to look into that matter, right? Madam ತೋರ್ಸ್ಬಿಡಿ ಏನಂತ. Yes. KSRTC. Just ಅದು ಒಂದು ತೋರ್ಸ್. Yes. He is anyway here before. 53 Muknappa after 2 weeks. Padke. When do you want? 17. Yes. Muknappa, call after 2 weeks. 55 call after 2 weeks. Shekhar, idavaga? Next week. First. I think by then, alla beda. 30th hakoli, 30th. Yes. 58 Praveen Kumar. Madam Sarojini Muttanna.
57.
Yes, that's 57.
Yes. When do you want? 17, 23, 24, 30, first?
First, let it be.
Yes, first. List this matter on first. Is Praveen Kumar? Mr. Praveen Kumar? Call after 2 weeks. Yes, Nayak ಅವರ ಎದಕ್ಕೆ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಸುಮ್ಮನೆ ನಾವೆಲ್ಲ ಯಾವ್ಯಾವ ಎಷ್ಟೆಷ್ಟು ನಾವು 23rd ಯಾವ ಕೇಸ್ ಪೋಸ್ಟ್ ಆಯ್ತು ನೋಡ್ಕೊತಾ ಇದ್ದೀನಿ.
ನಿಮ್ದು ಯಾವ್ದಿಲ್ಲ?
ಇಲ್ಲ ನಮ್ದು ಎರಡು ಸಾಕದು ಮುಗ್ದೋಗ್ಬಿಟ್ಟು.
You just look into that, Mr. Shekhar, that lady's matter. Yes.
239 Mexico. 2024 ಅಲ್ಲ?
Okay, bye.
ಇದು ಆಫ್ ಮಾಡಪ್ಪ.
Hello, madam. Thanks, sir.